How are you? Not bad.
I was getting it about. Come on. But then I
Do you recall the case, I believe we learned it first year, that talked about a social host's liability for drunken patrons?
Yeah, I know the case. I don't know the name of it.
Yeah.
Yeah, it's the one about the in-laws.
But I feel like the social host case was like a party at a house.
Yeah.
Well, you get that, like,
My question is, so instead of giving out drink by drink and having somebody pay it or whatever, at Dolan's birthday party, you pay a cover and it's open bar.
Mhm.
Does that release somebody from post liability? If somebody gets drunk and drives, is Fantasy still liable, or is, is it a workaround?
well, first let's always keep in mind that you're on reservation. So let's set that aside, because you gotta know they're allowed to make a lot of their own rules in this area. So that's number one. But because it's a safety issue, and because what are we calling again?
This seems to be a cool workaround.
It is.
Sounds to me like it should be a workaround, because you're getting yourself messed up, rather than paying again. I don't know.
Well, no. Well, let me tell you the problem that other persons have brought out. It's like I paid for all I could drink, and now you're telling me I can't drink all I want.
Well, sure,
That
but
doesn't work real well.
that's not a good argument. Yeah.
I'm cutting you off. I don't see that. So yeah, that's kind of the problem is you're sort of, yeah. But yeah, they can get in trouble for it. Without my mind. Question is, what would the line be?
You guys talking about overserving?
Yeah, overserving.
Oh, I asked that question at the Great Hunter to one of the waitresses, because one night I was just like, I'm gonna get a drink every time they offer me one. I was like, at what point we're gonna cut me off? She's like, I just give people drinks till they stop, until they tell me not to.
Yeah.
I was like, how far are you gonna push me? I'll just keep offering me a drink every time you come to the table.
Where were you? I'm gonna go there.
At the beer hunter.
Oh, beer hunter?
Yeah.
That doesn't shock me somehow.
They don't train the waitresses as well when you see them in class.
Kelly versus Gwinnell?
That sounds
Is that from your notes?
No. Some Google.
I think so. It's over here.
This,
You guys looking for case law?
yeah, it says the recent campaign against drunk driving led to the New Jersey Supreme Court's decision in Kelly versus Gwinnell allowing an injured third party's negligence action against a social host who served an adult guest beyond the point of visible intoxication, knowing that the guest would seem to be driving.
It's a business or was it a house?
That was a house.
It's not fair. Is at home you expect to get the other person visiting succeed?
I don't know.
Just have them pass out on your floor.
Yeah.
Just don't let them drive afterwards.
They can sleep outside on the patio.
Yeah.
I'll put my blanket in a pillow.
Yeah, that's fine.
Maybe it's out, you know?
It's not freezing right now. It's
Find a nice spot of carpet.
Put you or a tile, hopefully, in case people don't put big and freezing.
That's good. Yeah, on the tile.
You can say that we're not getting invited again.
You can never go to my fucking house again. And if you do, you're getting water.
You turn away the doors. Stupid.
What now? Yeah.
Getting mean Facebook posts, no one ever invites you to parties again.
Yeah, exactly. I'm gonna disparage your good character.
You're a responsible character for drinking too much water.
I've been to school for too long already today. I just want to go home.
When did you get here, by the way?
I got here at like 3.
Oh, that's like 45 minutes before I did.
Because I had jury duty, and then jury duty let me go. And I was not about to drive all the way back to Palm Springs to just have to drive all the way back to India.
Yeah, I feel bad about eBay because it paid out like $30 million.
Poor eBay.
They're blatant infringers.
Oh, no.
Then they paid, so that's fine. They paid out.
They settled.
They settled, it's fine.
Otherwise, you wouldn't have your buy it now feature.
Yeah, this app on my front page. Now.
What's the good news, Professor Drucker?
I'm sorry?
What's the good news?
Good news. No. Do you really want to know?
Not everyone.
Well, it's very odd. You should ask me that today.
No,
Oh, is
it's
it?
news.
Yeah.
Well, I was just, you know.
Strangely enough, I'm like, oh, well, since you asked.
Go ahead, no,
Don't ask questions you don't want the answers to.
No, it's actually quite odd. Today was the day I saw my doctor, my oncologist, and I went for the results of my 1-year PET scan. You get one in the beginning, then you get one at the end. And he said, I declare you cured.
Ah,
So
yeah.
it was a very good day.
nice. A year with no cancer.
No cancer. He goes, if you were to walk into someone else's office and say, check me for cancer, they'd never know you had it. There's no way they could. He says they figure it out from your scars, but other than that, they wouldn't be able to.
Cool. Congrats. Yeah, that's a great day. That is very good
So I
news.
was very happy this morning.
And you said no, you didn't want to hear it. You're an
well.
asshole.
I made up for it.
Wow.
Yeah, I'm waiting for the person when I tell them that I go, that's one of my relatives. Art collection. Yeah.
So what you're saying is I'm not getting the inheritance that I was promised.
I'm saying not yet.
Not yet.
I'm saying not so bad.
I'm not saying never, I'm just saying you still can't piss me off for another couple years.
I'm gonna
There's still enough time to write you out of my will.
Okay. Alrighty. We're all here. I brought you some more pain. Another needle killer. A lot of people just completely freaked out about. Okay, 15 minutes. Time, please. That was one of those where people just melted in your seat. And yeah, this one's kind of tough. This would, I think, be the difficult category.
I think I worked for 4 years after I passed the bar at my paralegal rate.
Well, depends on your loan, right? If it was like a $500,000 loan, maybe.
No.
Not out of this school, no.
So I'll be back in a second.
Oh. Some performance. It's not gonna happen.
People work slave labor.
I know. Okay, so statute of limitations.
It's like novation one.
Contract by its terms cannot be completed within 1 year.
There you go.
Statute frauds.
Latches.
So what's the average clerk wage?
I don't know, but I'm gonna argue it's unconscionable because you're supposed to bring defenses.
So what is it though?
So that's only 5, right? That's why. I mean, yeah, that's the question. Is it?
So we have 30,000.
Well, the statute of breach of contract is 5 years. I didn't see that one.
No, it says right here 5 years. So
Yeah.
in this universe, it's 5 years.
Oh, they want you to bring in bail, I guess. Maybe latches. But it is in writing, so statute of fraud doesn't apply.
Yeah, but it isn't signed by the person to be charged.
Yes, right?
No, he accepted orally.
Mm-hmm.
Oh, that's on it. What's the legal argument when one person has all the power in the negotiation?
Unconscionability.
It is there, right?
Yeah.
Okay. I got that.
I don't.
Do you have to argue formation and stuff?
What's it called when you take advantage of somebody? Like you insure, it's sort of like unconscionability, but it's like the uneven bargaining power. That's just one of the elements of
Unconscionability.
the 2 elements of unconscionability. It's like, what are the 2 things of unconscionability? I forget. I saw. How long? I wish I had learned this stuff.
The rescission.
That's not a defense, though. That's a remedy.
I know, but it's a remedies class. Just plug it in there. 'Cause I ran out of things to do.
What's it called?
What about something like undue influence? I mean, there's something back to that at the beginning with the naive understanding.
That's what I would say unconscionability.
It's 30-year plus his clerk wage, so he's still making less than he would have had he just got a regular job. As an attorney. Sam support his choices.
Oh, what's it called when you,
Innovation. Oh, I'm just kidding.
no, is it recorded satisfaction?
No,
That's if you pay it off
that's if you pay a different amount.
and agree to it on paper.
Right. So what is it, him saying, oh, we respect your choices,
They just say
right?
waiver.
Put waiver, innovation, and put all that in.
Waiver.
Novation is also not a defense.
I know, but why not?
Sure it is.
Novation
I
is
literally
about-
bring novation as a affirmative defense on my answer sometimes. Literally. And accord and satisfaction. Like I literally bring it as a separate individual affirmative defense.
Yeah, I guess if there was a novation, but
Sometimes close.
Yeah, he said he would support his choices of employment. Compare. I don't know, man. You spot an issue, you call it out. It
I would
doesn't have to be right.
spot that issue.
You don't have to spot it, just say it. Man. It's in that realm of.
You have to spot it to say it.
Like that. You can just say it.
Well, then I'm going to say comparative negligence. Contributory negligence.
There's still.
Assumption of the risk. You pay for his law school expenses before you paid him his check for $120,000, or before you got a letter of intent to work for you. Assumption of the risk.
At least we're in the same ballpark, man.
That is the
I'm
same
going
ballpark.
down a mental outline here. You're going on like a whole
You told me if I spot the issue to say it.
spot negligence. They had to do
Yeah, they were
causation.
negligent in paying his school expenses before they had a letter of intent.
Look, do you have any of the other
Those people
duty
need
breach
contracts.
There's no duty breach causation or damages, but I want the defenses for negligence.
Well, there is damages. There's $120,000 in damages.
Because
Chris had a duty to work there. He breached that duty by quitting. The breach of his duty caused the damages because they had already paid it. Therefore, there is actual and proximate cause, and therefore you can raise the defense.
I mean, the real thing you can't miss here is unconscionability, right?
And latches, and statute of frauds,
Yeah.
detrimental reliance, the 13th Amendment,
Detrimental reliance.
that's a good one.
13 is pretty good.
unconscionability, waiver.
I sort of brought 13, right? I just said two specific performance, personal services are not enforceable. 13th Amendment.
Or employment. Public policy.
It's not slavery, he's already got a student loan.
What?
See, it's not slavery, his student loans are already paid off.
No, but specific performance.
Yeah, you're gonna force you to work and stuff.
I mean, it's not the 13th Amendment because it's not involuntary servitude without compensation.
Then he gets-
It's just the court won't order it.
No, because it's against public policy.
And now he's no longer first year laws, he's a lawyer with 3 years of experience in it.
Right?
So he's not they really want his full experience.
Why do I care that his father died? What does that have to do with anything?
What you gonna do when he's down, man? His dad just died. They should just pay all the bills.
I think that it goes to his not being part of this contractual understanding, you know? I just have everyone going, pay the law. And you're sitting on these little kids like, I don't go to law school too.
How's it going?
It's a weird question.
Yeah, it's really weird. Everyone went, what?
Also, we want specific performance. You can't do that because now this guy's a 3 years experienced lawyer. He's no longer a newbie.
Okay, you a couple more minutes, see if you can flesh this out. I like this question though, because you have to go through a bunch of stuff, which is nice. You know, again, better we do these things now, you know, you don't want to get surprised by these things, you know, when you take the bar. Particularly the remedies question, I mean, they've been asking so many remedies questions, it's just, you know, just gotta, you don't not ready for remedies, it's just totally on us. You know, they've been warning us for years and now they're baiting us with it. Although there was no remedies on the last one, except maybe toward the remedies.
No.
No actual remedies question, yeah.
Oh.
Yeah, I got the lowdown, got the whole thing. I don't know, to be honest with you, I think that Brady would have passed when I heard the lineup and what they asked. You know, I'm a tenant, you guys will be pretty good at that. There was a weird evidence civil procedure crossover, which kind of threw a couple people.
Yes, that one doesn't make any sense.
Nice.
But I heard it and they told me, I said, that's really not that bad.
What, do you know what it's about?
Not yet.
Okay.
No one's given me any particulars yet.
Mhm.
But it was but it was definitely evidence of pro. I mean, there was no doubt. They just put it down for you.
Yeah.
So that one threw.
That's real life right there.
Yeah. Oh, yeah, exactly. But I think you guys would do really well because those two go together really all the time.
All the time.
Things.
Yeah.
So it wasn't weird. There was a straight PR question. No problem there. I think you'd be okay with that. It's a tort question. It was a negligence, strict liability, wild animals cost thing.
There's so much to learn.
So that was kind of an interesting one. But again, you know, strict liabilities. What was the other one? One more. It's wills and trusts. That's right.
Ooh.
Now, some are saying wills and trusts community property crossover, and some are just saying it was straight wills and trusts.
Well, if they're married, then it's probably a community property
Was anyone
crossover.
married?
Yeah,
That's the
exactly.
very first thing I said. Well, yeah.
Well, then, yeah.
They don't have to be married. What if it's one of those girlfriends that has all these rights?
Oh, right,
Except
Marsden.
Yeah.
Marvin, yeah.
Marsden, yeah.
Marvin case.
Marvin. Those guys.
Could be. And then the PT was a
DA
forfeiture
brief.
The DA brief about forfeitures. But they said it was pretty easy. They said, you know, it laid itself out really easy.
Those are dangerous though, because everybody's gonna do pretty well.
Yeah, so
Everyone
everyone felt pretty good. Everyone came out going, it was a lot of work. You know, it was like, they don't remember having a bar where they wrote that much. But I don't know if I was telling you guys this, but I was telling someone this just the other day. They're moving to a new, you can see where they're going now, and more is more. You know what I'm saying? More is just more. It's like they just want you to fill your pages now, which is what they used to do years ago. You know, years ago it was more is more is more, just more and more and more. You know, and then it sort of became like, we're gonna lie to you and talk about, you know, analysis, so less is less. And now it's back to more is more.
They really can't have that much analysis when the racehorse is like that.
Yeah,
It's basically
exactly. They
like,
want
you
to
just see
get-
everything.
Which is great because it totally plays in my stuff. Totally plays in my stuff because I'm a slow reader and a slow writer. So I don't think, I just go.
Yeah.
Let's just do this, do this, do this, and go as fast as you can. So, I mean, when I took the bar, there was very, very little analysis. I guarantee it, very little. I mean, of all the issues. I mean, it was always, to me, about getting to the next rule, getting to the next issue. And then analysis, every time I go sideways, I feel like I'm wasting time. Just like I wanted to keep going down, you know, just to make sure I didn't miss anything. So very rare when I think most of my biggest paragraph is probably about that big. And just moving on, you know. So that seems to be the trend, is we're seeing them, you know, do more, like rewarding you for doing more, even if it's not, you know, in order. Well, order's good, but even if it's not really the main issue, just the very fact it's even in those little
Yeah.
cubicles we've been making lately, it seems to be working pretty well. Because if you think about it again, it's kind of like, well, what are they going to do to you? You know, they can't subtract points from your score because you write something that's not on your score sheet. It doesn't matter. So if you're hitting everything, you see how you're hedging your bets.
Yeah.
You're kind of forcing their hands, and that's pretty hard to do on the bar. You know, they got a lot of. They're slippery. You know, don't be fooled, right? They're fair tests, but they can be slippery. You know, they've got their reasons how they get the people to go, you know, chase their tails. They can do that. They're really good at that, I have to say. So the heads up on the multi-states this time, by the way, was, I don't know if you guys are following that closely, but last bar, they dumped about 30 new ones in the last one. And of those 30, about 20 came back again. So there's like 20 out there that people are going, what? Things like that. So there's 20 that be probably down the bar that you may have never seen. So, but again, that's not necessarily that bad though, because one of the things that I understand is that when they do these multi-states, you know, they'll usually throw about 30 when they do new ones. Now, what they do is they usually throw out about 10. And then they keep the ones that, you know, they're going to keep. So they keep anywhere from 15 to 20. Again, it's what I've been told. But all it is just a ranking. The ones that students get, they keep because they figure, hey, they must be good. The students are able to get them. They're fair and everything. The ones they don't get, well, what are you going to do? You can sit there and fidget with it. I mean, you've already shown it to 15, 20 legal scholars. So what are you going to change? You're just going to wait for what? You know what I'm saying? Does that make any sense?
Mm-hmm.
I mean, why do you want to try to change the question, or do you want to see if they get it right? They won't do that. They'll just throw them out and say, well, obviously we see it one way, but the students see it the other way. How do we, you know, bridge that gap? And I think it's fair to say that when they're asking multi-states or anything, I mean, you really have to have a fair chance based on evidence that you should be able to answer that question, right? I mean, that's not a stretch at all. Well, that's good evidence, right? The 10 you throw out is not good evidence, right?
Mm-hmm.
So we'll watch out maybe on the multis, or maybe between then and now in the bar, maybe we can do a little searching, if we can find someone who, you know, because fortunately, you still have enough time that these might come out. You know, they might come out in a fairly similar form. So we'll see what's going on. But let's keep an eye out for that. Let's see if we can sort of just keep our antenna out, because things will get bandied about. So I'm gonna be looking. So if you guys find anything, let us all share them out. Yeah, because I mean, I'd be interested to see them. Apparently they're a little weird.
The multi-states?
Yeah, they're a little odd. They're just quirky, you know, just quirky stuff. So. Quirky's cool. We'll get it. We got plenty of time. So, but otherwise, you know, I think it's something that just from what I heard, again, I haven't seen the actual questions yet, but I would have been very, very pleased to have had the three of you take that bar. And I think that's a good sign. I mean, they're not going to change dramatically anytime soon. I think this is the new way. And so I think we're doing great. I think we're really going in the right direction here. So, all right. Now this is kind of a little bit of an old one, but it made a reappearance in kind of another form around 2017. A couple of years ago, they had another question kind of like this one. So it does come back every so often. Okay, everyone kind of got the basic drift, right? It's kind of a contract-y, right?
Mm-hmm.
Remedy-y thing, right? And if you see it, it says contract/remedies. Very remedy heavy, to be sure, right? Lots of weird remedies in this one. But in fact, you had to talk about contract law. Yeah, both model answers have a fairly, not robust, but they have a pretty good discussion of contract law. So again, this was one of those it'll end in tears questions where a lot of students got caught flat-footed. They just did. You know, they saw specific performance, right? Jump off, engine, building, whatever they did. Okay, you wanna take a peek? You wanna just go through it real quick? Okay, let's go through this one, because it's a good question. Good question. Good to know too. Breach of contracts and law firms, what's wrong with that? Anyway, with that said, okay. So, what legal and equitable defenses? So, again, here we go. They're starting with legal and equitable defenses. Well, obviously, you talk about remedies as well. It's kind of a funny way to put it, but so be it. Chris, now notice again, very low standard. Okay, reasonably present. This is pretty low stuff. So when you see something like that, your first inclination has to be, if it's reasonable, I'm gonna throw it in. That's a very low standard, okay, especially with defenses. Considering I don't think I ever wrote defenses without writing 15 at a time. Here's our defenses, at least 15. So again, not a problem. Remember, in real life, if you don't state your defenses up front, you don't get them later. So that's one of the things about answers, don't ask me for answers. You claim it, okay, you can bring it up later. To defeat the relief sought by law firm. Weird. And are they likely to prevail? Discuss. Okay, fortunately, it didn't end up being a PR crossover. That would have been I think of even worse variety. I didn't say that. No one heard that. Don't tell the board though. Okay, in 2001, Lou was the managing partner. Okay, so managing partner of law firm X in state X, and Chris was his paralegal. Again, they're trying to, you read that and you think to yourself, okay, so managing partner, that sounds like business associations. Law firm in state X, that sounds like civil procedure, and paralegal, whatever that is. But again, they're very good at doing this, okay? Very good at we know it's equitable defenses, but realizing that Chris intended to go to law school, Lou invited Chris and his father to dinner to discuss Chris's legal career. Okay, that's kind of background. Aware of Chris's naive understanding of such matters, so what does that sound like? Are they, again, if we're talking contracts, does it sound like these are two people that really would enter into what we would call bargaining? One seems to have a lot more power than the other. So what's the first thing that really should come to your mind?
The procedural unfairness prong of unconscionability.
Excellent. That's a huge issue. Huge issue. Big, beautiful issue. Okay. Good call. A lot of students went right over it. I tell you truly, they just blew right through unconscionability. Who was your teacher?
See, I would have started, I would have done any contract analysis at all. I would have started with unconscionability and then got weaker and weaker and weaker as I went on. To me, the scary thing is, why the hell do you want to discuss the contract?
Yeah, I didn't.
Just first line, unconscionability. It seems like that would be.
But then what is unconscionable? We understand that there was.
Neither one started with it. Both of them started with contract formation.
I usually have to have an unconscionable contract.
Yeah, you have to have a contract to prove that it's unconscionable.
Yeah. No, you're right. It just,
Yeah, there's no, I don't fault you for it.
But the last one that we did, they didn't start with the contract. They just went straight into the remedies. So it's like,
your discussion of remedies would be so good.
How do you?
Because I showed you on that one again. That was my whole argument. Though. It says it's a valid contract, so it has to go into formation.
Don't forget, I'm telling you though. Remember, even if they say valid contract, you can pick up a few points, or you can really try to. You're always trying to bring the reader on your side. And one of the things you can do is show them that you're not doing the bare minimum. That I've got no timing problems. And so even if it says valid contract, I would say here the facts tell us it's a valid contract. Therefore, let's assume whatever words you use, there's an offer acceptance consideration and lack of informational defenses, including the statute of frauds. Let's move on. Well, how smart do you look then? It's like now you're telling the reader, you're not going to fool me. Nothing's going to get by me. I practiced this. I'm going to respond to everything have at you. And then all of a sudden you see how you're see how you're getting them on your side.
So the statute of frauds would have been your first thing here.
That would have been my first real issue.
Okay.
Big statute of frauds. But they both started with, they just did the contract thing, controlling law, valid contract, offer acceptance. They both did that. Consideration. The second question did it in one paragraph. This one broke it down in pieces, but they're almost identical, really. So again, but I can see why I might do that. Again, I'm sort of, this is how I write these questions, is what you're telling them. So, let's see. With the authority of law firm, what do you think that sounds like? Authority of law firm. Just out of curiosity.
It's an agency question.
Sounds like agency to me, doesn't it? Yeah, so again, I don't know, I mean, that's what it sounds every time I read it. Made the following written offer. Okay, so statute of frauds, we put it in because we pick up points for that. Again, do you see the word statute of frauds in here?
No.
It says written, pick up points. I'm sure it's worth one or two.
Well, no, the next, if you finish that sentence, then it becomes a bigger issue.
It's a bigger issue, yeah.
Yeah, which Chris accepted. Well, okay, big time now. Okay, that's it.
It's like literally a way to get off, but then that wins.
Right. So
See, and that's why I
agree,
would-
the first big ticket is statute of frauds. I think everything else.
That's why I wouldn't do
The contract analysis, because I would legitimately just throw it out once I hit statute of frauds. Like, that's literally the only defense he needs to raise, because statute of frauds throws it out.
Right, but
So I
how do you get to the statute of frauds? Sometimes it's worth showing that.
See,
It
and
really is.
in this, since they only asked for defenses, my first one would have been statute of frauds, because that's the first defense that I would have saw other than unconscionability. And I would have said statute of frauds, and then, a written contract requires offer acceptance consideration, but I would have done it all under statute of frauds rather than done a whole drawn out conversation on offer acceptance consideration to get to statute of frauds on top of all the other defenses that you have to do.
Okay, let's keep that thought in mind for today. Okay, we start from where we're on, and then go forward. More is more now. Okay, so let's think about more if we can. But let's have this discussion so that you feel comfortable with more, or in fact, if relevant, less. Because there will be those decisions you still have to make. Okay, there's going to be some stuff you're going to have to cut, whether you like it or not, because you can't write everything you know. As much as we love to do it, you run out of time. So, anyway. Okay, 1, after graduation from law school and admission to the bar, so we've got some preconditions there, law firm will reimburse Chris for his law school expenses. All right, it's pretty straightforward. Those are some terms of the contract, right? So that's why I also tend to think you might do some contract, formational issues, because again, because you can. I mean, I don't really know another reason. Chris will work exclusively for law firms. That's kind of interesting. For 4 years at his paralegal rate of pay. Okay, paralegal rate of pay, commencing immediately upon his graduation and admission to the bar. Okay, in the world of work, in the world of employment law, that's probably against public policy, by the way. That's a virtually slavery. In my mind, I'm like, you signed what and did what?
Yeah.
Lincoln freed the slaves. So I don't think that's going to fly in today's society. I'm sorry, but that's just me. That's the unconscionable part, by the way. That's where you see inequality.
Mm-hmm.
I mean, maybe it's not. I don't know. He pays all the expenses. Hard to say. I don't know.
So they're still shelling out 120 grand.
Yeah, I mean, it's not like it's, not chump change, but I don't know. Well, but this is California. And remember, we always have public policy in this state is always against these kind of agreements. So you have to prove it's not up to Chris doesn't have to prove it's unfair. They have to prove it's fair. Otherwise, it's by public policy, it's out the door because it's anti-competitive. It's right to work. We want people moving around. We want people moving up. So On the other hand, it's not a terrible deal. So, let's see, and, Chris will be offered a junior partnership at the end of the 4th year if his performance reviews are superior. Okay, that's against the terms, but what else? What's the problem with them paying for past law school expenses, by the way? Anyone remember from your contract class? You may not, and it was a long time ago, but what's wrong with you saying things like, well, we'll pay?
Wasn't that an issue with consideration because it's
issue? Excellent.
a past performance?
Yeah, that's a problem. That's a problem. Made it in both papers. Again, another one that I really think you have to catch if they bring something like this.
I just feel like there's way too much. Would you bring that under consideration and information?
Considerations. Again, another reason why I would have talked about
You
formational
do need to talk about formational issues, because there are formational issues.
Yeah, and this is maybe an illusory promise, right? It's for past consideration, brings up a lot of issues.
Well, it's definitely illusory because his performance reviews are completely subjective. I mean, the law firm doesn't watch his junior partner. Oh, no, you're not superior. Get out.
You average flunky.
Yeah.
He has 4 a year, right? So that's 16. Let's just say he had 4 a year. And so they do 16 and 15 are excellent. Last one, you suck. Out.
Yeah, exactly.
A law firm do that?
Oh, never.
Whoever thought of it? Yeah. I knew a law firm once. I won't say who. But anyway, so there's this law firm once. And you know what they used? Seriously, I'm not kidding around. Honestly. And this is not funny. They really used to do that. They were bad boys and girls, a couple of them. And one of the things that they liked to do, because they thought it was funny, was, anyways, they used to like to hire kids, like, right out of school and stuff like that. And what they like to do is they like to hire them and bring them over, from out of state to California, or from, they have to move, basically. Sometimes they're from out of state, sometimes they were from San Francisco and things like that. And then pretty much they'd get here, they'd check in the first day, and they'd fire them. Just, we changed our mind. And then the student would have, brand new.
Can't you sue them?
And they'd say, all right, and they'd say, sue us.
Okay.
They didn't care.
They detrimentally relied on your promise of employment and moved how many ever farther away, and you just change your mind?
Yeah. They thought it was funny.
It's fucking sadistic.
That's.
And then during the discovery process, you get all their emails regarding it. Oh, it'd be an easy suit, I think.
Yeah, they're just telling you they used to do it.
And once you win the lawsuit, it'll be like you passed your test, you're hired.
Yeah, exactly. Yeah, probably.
That would have been kind of them. I'm just saying.
You sued us and won. Okay, you can have job now.
They just you write a good complaint, give it to, because you're brand new out of law school. And instead, you stand up to them, write a good complaint, and they're like, good job.
You're like, no, actually, it's already been filed, so you better answer.
Yeah, they'll give you a raise.
You just made junior partner.
Now, just so we're clear, I was not one of the attorneys. They actually told me that because they were proud of it.
You were proud of it?
Well, they thought it gave them the bad boy reputation.
Really?
Oh, yeah.
Okay.
We're badass. We whipsaw attorneys.
See, what I would do is,
Well, the question is that if they weren't really working out quickly, that's different than saying we brought them in and fired them because we thought it was funny.
No, they were didn't care. They were going to fire them. It was already pretty much a
But it was
foregone
like they had a 30% chance of making it here, or was it we're just bringing them in to F with them? Okay.
Yeah, totally. Totally.
I thought of that Van Wilder movie where he's in Britain.
All I can tell you is I thought she was lying. And I said, you're just, come on, get out of here. You guys think you're so blah, 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 blah.
That's how you get shot.
In front of me.
That's how, I mean, honestly though, that's crazy. That's how you make somebody crazy.
That,
Dude,
they would be crazy. Yeah.
That's insane.
Yeah.
No, you open up a practice right next to theirs, hire everyone they fire, and then it's the team against them, and since they already moved in the area, and they're desperate for a job, so you pay less than what they were offering.
So that's just insane.
Pretty much, yeah. But anyway, just, again, when I see questions like this, I go, Anyway, so 2005, Chris graduated from law school. Does that part? But again, that seems rather illusory because that's not really consideration, right? I mean, that's for his benefit. What's it? Again, it's worth the discussion. And was admitted to the bar. At which time law firm reimbursed him for $120 for his law school expenses. Okay, so almost that seems illusory as well to me, because what consideration has he given them at this point for the $120,000? The answer is nothing.
I think it's just a promise. Well, you don't have to tender it. You have to. The exchange of consideration doesn't. You just have to be an exchange of detriment, right? So his detriment is probably going to be illegal or unconscionable or whatever, but it's the promise that I'm going to work for you for 4 years, right?
Mm-hmm.
And
that would be
that's a legal detriment. I mean, it might be an illegal detriment, but it's a detriment, right?
But don't they have to
anything that you have a legal right not to do that you do is basically illegal.
Don't they have to be simultaneous though? Like the detriment and the benefit? Because I know like we learned the cases where
can be the past performance problem.
If if you get good grades, you get this much money, and then they're like, oh well, that's the bargain for exchange because they're giving up like some, or like if you don't do drugs, you'll get this amount of money. And they're like, well, you have the right to do drugs if you want to, so you're giving up that right, which is your detriment.
And that's kind of a detriment.
But don't they have to like, do they have to pay you while you're giving up drugs, or can they say if you give them up for so many years, then we'll give you like a lump sum payment?
Well, but that's what they do. They say if you go through your, college years and you never do any drugs, I'll give you $12.
Yeah, and that becomes a contract because you're giving up something, but
that's okay, I think, because.
But then why isn't it
But then
still
the problem
past
is it's part of the
performance?
past performance problem. See, that's why it's not a good fit.
I feel like all contracts are for past performance. So I mean, you build me a house, I'll pay you money. I mean, it's still past
But
performance.
this is
Well,
before
no. It's not for the. Remember, it's not for the performance necessarily. It's for the promise. Most contracts are promises for promises, not promises for acts or acts for acts. Right. So the fact that you are willing to promise to do something means that in the future you'll deliver it. But that's a promise. So most contracts are promises, right? You don't do them right on the spot. And very few, as a matter of fact. Good point. I like that actually. Gotta remember that. That's good. Most contracts are not for actual acts. They're for promises. Something you'll do in the future, like paying tuition or something like that, right?
Mm-hmm.
You let the month go by and then you pay for the next month. So really what those contracts are for promises. So that's kind of where that breaks down. So, but that's
But
interesting.
isn't this still technically a promise, or no?
Well, this, I guess kind of, they did this before, while he was still in school, before he went to school, right?
Well, I mean, here's the thing.
Because I feel like this is like kind of, ironically enough.
There's three kind of let's just do this real quick. When you get to this level, okay, there's three basic components that consideration can be. I mean, again, to say that it's the car for the money or something is kind of, it can be promises, acts, and detriments. That's it. There are no other consideration components, actually. So you have to find there was a promise for a promise, because they have to be mutual. Promise for an act, a promise for a detriment, whatever it is. You have to find it. It's one of those three. If it doesn't fit in those three, it's not going to be consideration. It's one of the sort of the tests you can do. And some do. Some weird stuff falls outside of it. It just does. So,
See, I just wouldn't have thrown this out for lack of consideration because I feel like people enter into these kinds of contracts all the time.
Mhm.
Like with Chris with Wally Clark, I mean, I'll pay for your law school, you work here for a certain amount of time after you're done with law school. I mean, it's basically the same contract, isn't it? So I mean, it wouldn't be void for lack of consideration because.
Well, I don't think so.
But he should be working as an attorney.
Well, so is that. So are they. They're just getting hated apparently the rate.
But what I'm trying to say is on the bar level, I mean, I'm trying to get you to see the necessity to do something about formation. You can't just leave it on this question. See, that's why I think a lot of students did that. They started with what? What do you think most students would have started with on this one?
Latches.
one of those. Yeah, they would have started with some kind of an equitable remedy is what I'm thinking. Which is, again, I think I can't say you can't pass, but it's just so risky when you do that. So
I probably start with statute of frauds and just
statute of frauds at
skipped
least.
over the formation and talked about formation within statute of frauds.
That's not bad.
But I don't think
That's not bad.
I don't think I would have felt safe starting with applicable law and then offer acceptance consideration on top of all the defenses that I still need to go through too, because that's specifically what the call asks for is defenses. I would be nervous to start with formation.
Yeah, see, and I think exactly the opposite. It's like I think, oh, now I've got to go through everything to get a defense, and my brain goes to the top.
Yeah.
And I say, how do I get through this so that I can get to defenses, not how I start with defenses? Because I can tell you that the paper that starts with the defense with nothing else, you're not. That's not their game.
Yeah.
That can't be. You know what I'm saying? Can't be. So, all right. So, okay.
I have a question about, we haven't gotten there yet, but statute of limitations, do they start to run from when the contract should have been completed or from when it's formed?
Oh,
breach would start at the time of performance.
Yeah, it would start at the time of.
Right.
Well.
Because you can't bring an action for breach until the party breaches.
Right.
So you can't bring an action for breach until performance is due. So
yeah. Well, or anticipatory repudiation, maybe.
Yeah,
Basically,
that's the exception. But I believe because even with anticipatory repudiation, don't you? Or no, even if they say they're going to breach, don't you still have to wait until the breach to bring the action?
Not with anticipatory repudiation. You can actually elect just to bring the suit. It's your election. When
It's the demand for adequate assurances where you still need to wait for them.
Yeah, you have to wait to
become
see
due.
if they say anything.
Yeah.
But then the contract keeps going. You're indicating your willingness to hear them out. But under anticipatory repudiation, you also have the option just to sue right there. I'm not waiting. If it's unequivocal, I'm not going to wait. I don't care.
But otherwise, the statute starts to run at the time of breach, right?
For sure.
Yeah, because they can have a statute for 3 years and your contract's for 5 years and you only perform for 3 years and you're like, statute of limitations is done, I'm just not going to do it anymore.
That's the statute of frauds. That's why the statute of frauds there gets rid of this conversation we're having here. We don't want contracts that run for performance, for services that run for more than a year. We don't want contracts that blah, 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 fill in blank. That's actually what the statute of frauds is there for, to a great degree.
I think it's just 3 dates. I'm guessing the date between 2001 and 2005 is the statute of frauds issue, and then the statute of limitations issue is from 2005 to 2008.
Yeah, this runs pretty far. Yep. Okay. Yeah. Let's see.
People have more than this illusory profits.
Okay, so he graduated, which time offer. They reimbursed him. That's pretty good. All right. Again, sounds interesting. Chris and his father invited Lou to dinner to thank him and the law firm for their support. Okay. Consideration. Sorry. What about the dinner? During dinner, however, I wonder if they had liberal arts for dinner, right? Another class. Sorry. Anyways, during dinner, however, that's a lovely however, isn't it? You're like going, oh, now what? That's the equivalent to that. Chris advised Lou that it was his decision to accept employment with a nonprofit victims' right advocacy center. That sounds so much like real life to me. Sorry. Anyway, Lou responded that although the law firm would miss his contributions, he and the law firm would nonetheless support his choice of employment, stating that such a choice reflected well on his integrity and social consciousness.
That doesn't sound like real life.
No. That doesn't happen at all. So what do you think about that, though?
I'd say it's a waiver.
Sounds like a waiver. Yes, no?
And if he had authority.
But what does he still have to do? See, that's where it's interesting. He does speak for the firm. I think it's fair to say that.
If he had authority to enter into the contract, he can have authority to waive the contract.
Mm-hmm. But but with the waiver issue, don't you think something else still has to happen? Can he retract his waiver? Is there a point in time where, oh, too late? Do we still need that to occur?
I honestly don't know. I don't think you can waive a waiver. Can you? Can you retract a waiver?
Until
Detrimental reliance on the waiver?
it's no longer waivable. The other party relies to their detriment. That's called what?
Detrimental reliance?
Well, but what's the bigger picture? Estoppel.
Oh.
Estoppel.
It's like,
Always remember that estoppel is one of the absolute greatest, best legal words, and I'll tell you why. It doesn't matter who you talk to, as long as they're not a lawyer. Just tell them that you're going to have them stopped, and they freak out. They have no idea what it means, but it sounds really bad.
I mean, how do you stop? Do you mean stop? No, it's stopped.
It's a legal term, and you're not going to like it. Oh, he's going to stop me.
Better than if I stomped you.
Actually, that's what that guy should have said. I flew out here. You're stopped. I'm going to get you.
Yeah, right.
Not bad. Yeah, these were really fun people. Their parties were a riot.
I bet they were, but
Pretty scary.
They were a local firm here?
No.
LA?
This is in LA.
I was about to say, right.
This is prime time central LA.
Welcome to LA.
Nonsensical entertainment world lawyers
So,
who are a breed apart. Let me tell you. I'll take them on.
So what?
Oh, well, if you ever went to a court with them,
when is
you
the,
plead
when
the
is it no longer waivable?
No doubt in my mind about that.
When you've relied to
You're
your
just
detriment.
playboys.
Also, on this,
Yeah,
you
these are
argue
the type
that
of lawyers that call
you can't do the
judges
job he's been
dudes.
working, so it's
Well, I think your better argument is you allowed him to take this job where you knew he wasn't going to get paid jack shit, and now you want him to all of a sudden pay you back $120,000.
Mm.
It's like he relied on your waiver,
So
took his job at this no pay firm.
So he doesn't have to pay back the 120. Makes sense. Now that he doesn't have to pay his $120,000 in school debt.
Yeah, he can work for the nonprofit and
Yeah.
make it somewhat on
That'd be the argument for a stop.
on bread and water.
Yeah. Did it pay? That's it. Okay, 2008, Chris's father died. Why did they say that?
I don't know.
To show that these are bad guys that are necessary.
I was thinking that it just may have supported the previous procedural unfairness. Like he brought his dad. Like you know what I mean?
I mean, the only thing that I can think of is that it gets rid of the witness to the contract.
So,
there's,
I know,
come on, go
parole
on.
evidence.
well, it's not parole
No,
evidence.
because that's the evidence.
Well, it's spoliation of evidence.
No, he's dead.
For laches purposes. He's dead.
Equitable remedies.
Latches?
Latches.
No, it's
I thought I
not.
just said that for laches purposes.
Well, you said it's spoilage
I said
for
spoliation.
latches.
Oh,
For purposes of
yeah,
laches.
yeah, it's latches. One of the main
But if I was-
purposes is not gone.
Spoilation, whatever, is when you deliberately throw out evidence.
It is.
I think it's
Isn't
just,
it?
I think just when evidence is.
I don't know. I don't think it requires it to be
Intentional?
I don't think.
Because I thought the whole point of spoilage was, okay, you threw it out, now it's deemed admitted because you got rid of it. I thought that was the whole point of.
Well, I mean, it
You're
only
thinking about something you
goes-
learned in criminal procedure.
Yeah, that's
That when the cops screw
But it's
stuff
still in
up.
civil
See, the only
procedure
place I've
too.
ever heard it is when they don't store something properly.
Right.
And it spoils, and then they're like,
There's something to do with spoliation that you're right about.
Yeah,
I just think it comes out of Crim Pro, and I.
But it comes out of CIPRO too, because I mean, if you
oh,
withhold,
it's in Cipro.
if you withhold
Yeah.
like pertinent business documents or throw them out intentionally or shred them, then it's deemed admitted. Usually, at least that's the remedy
Yeah.
for whatever that is. And I thought that was spoilage. I thought that was all intentional conduct. Like I didn't think somebody dying was spoilage because they're dead. It's just evidence has gone away.
Yeah, I think you might be right, actually.
You might be right, because really what it comes down to, it has to be, you're really testing my memory now. it's,
It's the
It has to be
intentional,
under
reckless,
your
or negligent
control.
withholding, hiding, altering, fabricating, or
yeah,
destroying.
it has to be in
evidence.
your control and it has to be
You're right.
something that you change knowing.
Feels
Yeah.
good to say
Very
that.
good.
For you,
Well, no, for you, yeah.
I just enjoy saying it.
But yeah, so that's why I don't get why they couldn't think he died. I mean,
Yeah, how
It's
does that
for
change the latches though?
but how does it go in? Because latches is just, you waited too long to bring the suit,
So
okay?
the other side.
It's not like you knew he was gonna die, I mean.
No, 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 it had nothing to do with that.
Yeah.
Latches just means that because of events that have happened and because you waited, that the other side is now has a problem with, because they can't call him, it's not for him.
Oh, because you waited, oh, so it's more, you waited too long and because of the event, the natural event of things,
Right.
you're now in a worse off position
Right.
and you can't
The other
present your
side can't
case.
present the case because all the evidence is gone,
Come on.
he's dead. So they've been put in a position that, and so latches won't work. That's the problem, you can
Well,
bring
latches- Latches will work, right? I mean.
Yeah.
Latches will work because he's dead. Well, Latches has a better chance of working because he's dead. And he doesn't have some. Well, no.
No, it's the other way around.
Because Latches is going to go towards the law firm.
Yes, latches works for, no, well, you want latches because you want to be able to bring the suit beyond the statute of fraud,
Statute of
statute of
limitations.
limitations. But the thing is if your waiting has influenced the other side's ability to present a defense, it won't work, it fails, latches fails. You see, wow.
Yeah, because the dad would have been a witness
Latches
to him
failed.
saying
The law, no, the dad would have been
I
a
always
witness
thought
to the
that
law
Latches-
firm.
No, but
The
also
law
it's a
firm is
second dinner.
happy dad died. So
Well, why does the law firm have
The-
dad
the
die?
second
because
dinner.
dad's gone, so we don't think the court's gonna put latches on, because you, by your own inactivity, you know. Well,
See,
actually,
I see the dad
he
as,
brings the suit.
I see it, I
The second
dad as a better witness for the, because the firm is the one bringing the suit.
Yeah.
And I see the dad as a better witness for the firm to show that the son accepted the contract.
Yeah, but they had a second dinner where the dad also saw Lou saying that.
That he waited to, I mean,
Right.
I feel like the dad kind of benefits both of them.
See, I'm pretty sure that if the like latches is the defense.
It's a defense. It's a
So
Chris
it's not
brings-
that latches fails. You're not trying to latch on like beyond the statute of limitations. Latches is the defense that says
You waited too long.
you didn't exercise due diligence in
Right.
bringing your legal claim.
Right.
And so but it's not that latches fails. It's that latches makes your case fail.
Like the doctrine of latches makes your case. I don't think it means like
Yes.
You fail yourself. The plaintiff will fail
Yes.
because you brought brought latches as a defense.
There you go.
okay.
Okay.
Okay. But you see how, you know, I mean, in this case, the law firm brought the suit,
Yeah.
but you can see that then the son is.
Detrimented because his father is now dead.
Right, how is he going to present a,
But can the law firm defeat latches by saying it also detriments us because the father was a party to the, or not a party, but a witness to the original agreement too? I mean,
I never heard that.
okay, I just didn't know if it was kind of like about, like if it affects you both the same way, then it just won't be.
Well, latches
So.
is just an old
It
French
is a
word
defense.
meaning
Yeah, I know it's a defense.
remissness, and it's the opposite of vigilance.
Yeah,
That's all that it means.
because you waited too long.
You wait too long.
But I just didn't know if it didn't work as a defense, if it also hurts the plaintiff. Because I mean,
I think it's more of a stall.
technically the father dying, it hurts them both equally. It hurts the firm by having the witness there to show that Chris accepted the offer, because here it's only verbal.
Yeah.
And it hurts Chris because because the father's now dead and it can't show that there's no witness to the waiver. So I feel like it kind of equally balances for the two of them.
But the father-
I just didn't know if that mattered or if it doesn't even get looked at on the plaintiff's side to show that it also detriments them.
Also, Mr. Waver, I missed that.
Yeah, it's funny because I'm trying to play this out in my mind, and because I've never heard anyone do that. See, so it's kind of like,
Like your latches argument fails because
yeah.
it hurts me just as much as it hurts you. Like
Yeah, I've
the
never heard
waiting.
anyone say that. So,
The guy
so they say, okay, we're going to sue you, and you say, but I want latches because one of the biggest witnesses is dead, and they say, we can't call him either. See, that doesn't sound like a good fit to me, because it's not your defense, it's your, I mean, you could, I guess, but on the flip side, you're arguing that they can still put on a good defense, so why wouldn't you say that? Interesting.
Because I mean, like,
I never heard it though, that's what worries me when I think, never really heard it. I'm not saying that it never happened, I'm just saying I've never.
I think it sounds like a great argument.
I just feel like a lot of the latches case, at least the couple that they mentioned in the book, they're very one-sided. Like,
Oh, yeah.
the law
Very
case,
one-sided.
you let the law get so far along, and now you're gonna bring the suit. And so that's very one-sided. And I feel like a lot of the latches cases is, you've waited so long, like, I detrimentally relied on everything going as it is, and now you're just saying no, but it has no effect on you, you're just saying no. Whereas here, you were both detrimented by that father dying almost equally.
Yeah, I mean, so I can kind of.
I just didn't know if you're, I'm very worried about the exceptions to the exceptions.
Yeah.
So I was just like, is that an exception to the exception?
Interesting question. Yeah.
I don't think it should matter. I mean, that's my opinion, but
But why does it get to benefit one side and not the other?
it's that you're looking at it wrong. You're looking at that now the trials, the problem is that your laziness resulted in a trial where we don't have all the witnesses.
But they're not lazy. I mean, they're
No, it is.
still
It
within
is.
statute of limitations.
Well, I mean, I think that's the point of latches though, is that,
No,
is that
there's
you
so-
you being,
Yeah.
maybe not lazy is the wrong word, but you waiting 3 years resulted in, now we both don't have that. Like,
I have a very busy law firm. I can't deal with the squabbles of my employment contracts right now. I waited until an opportune time.
I don't know. I knew I had 5 years.
Yeah. I just didn't know if you knew if that was like an exception to latches, like if it equally detriments both parties.
So it's funny because I can't say,
You can't say no, but you also can't say yes.
I just don't know if it.
Just argue both sides and move on.
I don't know how much weight it would be given. Yeah, but I can't say no because I think I would say it, But it's funny that I've never heard anyone say that. That is so odd. Because usually, yeah, but if you heard of people doing that, or we talked about it, or we do it.
So if you remember when we used to have the questions instead of pro, and he'd be like, never thought of it that way.
Yeah, I mean, every so often I run into something, I don't know, I never really even care.
Well,
Doesn't mean we're right.
I don't care for essay purposes because I know I can argue both ways and move on.
Yeah.
But if this is a multi-state and they're like, what's the best defense? I mean, most people would be like, latches, the father's dead. But I mean, if there's an exception to latches that say, well, they're both equally relying on that dead witness, so it cancels out, then your next best option is unconscionability. And it's
Well,
like,
I think even if the
hey,
witness
multi.
helps,
But I don't think it helps the law firm much because he will be a witness to, made a contract, but he's also a witness to you waived that first contract that was also there to witness.
yeah, you waited till we're losing key witnesses, man. To me, like, that should be the point. Like, whoever relies on them is almost like a second. They're dead. I don't know who they're gonna help.
I didn't know the father died.
Well, but
You know what I'm
here's a
saying?
big question. Okay, but just so we focus though. The question becomes, when you're using latches as a defense, it's like, because of your waiting, like the other side's
Your
waiting,
procrastination.
your procrastination, right? That during the time period that there was a significant loss of evidence and witnesses to the degree that I can no longer adequately defend myself. That's the defense. But it has to be because of your laziness. Now, the problem I have with this in this case is that they're still within the statute of limitations. Does that change your analysis?
I mean, the only reason
How are they lazy?
The original reason that I raised latches wasn't because of the father's death.
Yeah, I like that argument.
I mean, I didn't even think of the father's death as really anything in this case.
Right.
I raised latches because
The latches argument.
you waited 3 years. You knew he was working at a nonprofit law firm. He'd never be able to pay you back $120,000, and you've now waited until 3 years into this position and now you want him to pay back 120 grand. I mean, you knew where he's going, you knew what his pay was gonna be, and yet you still waited? No. I just saw the father as like,
another year.
you lost a witness.
Okay, let's go on. How do we move into the public policy, the 13th Amendment, personal services, how do we move into that? Because you know what I'm saying, like there's a whole other side of this about like, because they want specific performance.
Well, the
and
answer is no, they can't get that because that's virtually
this is against
Yeah.
public policy.
Yeah, it's against public policy, go down the road.
But it's specifically,
I think you do like legal defenses, and then you do equitable defenses. And you just break it down like that. And be like, the legal defenses are, statute of limitations, statute of fraud.
It's funny because also the way that it works in real life, just so you know too, having dealt with this issue numerous times. I can't so many times I can be today. The problem is not that when they ask for a specific performance of a contract, when you breach a contract for personal services, they can't make you go to work.
Right.
Yeah.
They can't. It's anti-slavery. It's an anti-servitude.
Thank God for Lincoln.
All those stuff. Yes. Thanks to Lincoln, nobody can do that. But the problem is you can't work
Unless
for
you're a person,
anyone
right?
else though. That's the problem because whoever you're dealing with, whoever has the contract, they can actually get an injunction against anybody else signing you for the same services. And they hold up.
But why? If you don't have a non-compete, how can they all of a sudden make a non-compete work?
Well, it's not exactly a non-compete in that case. It's a situation where, I'll tell you why I dealt with it. I won't give any specific names.
Employment contract for an entertainer?
Well, I used to work for a lot of musicians, some of which were very well known, and they love to break their contracts. And remember that their contracts are in California anyways. The longest contract you can have in California for personal services and not getting into trouble like the next day is 7 years. Just so you know.
Wow, that's long, I think.
That at common law, that was the longest a servitude contract could be for. So it's 7 years. Okay, otherwise you can bring a common lawsuit.
What servitude are we talking about?
Any kind of
Like indentured servitude suits, like the ones to bring people over.
Like you signed an employment contract to work for you for so many
I'll
years.
work for you for 7 years. Anything at common law that was for more than 7 years was per se
se
invalid. So we still have that in the common law. So the way that that's expressed in, not so much anymore, but in record company contracts would be, a basic 3 records, and we would have the option for the next 4. Right, so you may or may not option your next record. It depends how you do, blah, blah, blah. But the bottom line is over a 7-year period, we want 7 records.
Well, that's what happened with Kesha and Dr. Luke is they said you can't get out of the contract because there was no fraud and
Right.
you didn't prove anything.
Right.
So you have to either finish your contract and record the albums or
do what?
nothing.
But why?
Because she had agreed.
You can't stop her from going. You can't make her.
You can't make her make the album.
You cannot make her go and do the record. I'm telling you flat out. That's anti-slavery. You can't have it. But why isn't another record label then just sign her? Say, hey, hell with you. Go sue her.
But, so do they get any damage from that though? Can they still sue her for prospective, damages on all those albums?
Sure. Well,
No, because they're too speculative.
Because remember, also there are options. That's why they're actually written that way to some degree. But if there is, they can sue her, and they can try to recover damages if there are any. But they can't make her do the record.
Yeah.
There's no way. You just can't do that. On the other hand, aren't you wondering why nobody else just said, "Oh, great, Kesha won't work with so and so anymore. We'll just sign it."
Not really.
I guess they can.
They can get an injunction against them.
Yeah.
If they go ahead and put it out, they're going to get all the profit from the record plus damages. Both.
Yeah.
So forget that. And then if it was willful, it's triple. You want to mess with that?
No.
That's the music industry in
Not sure.
in that area anyway, in a nutshell. That's crazy. If it was me, I'd be like, yeah, I hope they do go ahead and do it. Because then I'm going to get all the profit, I'm going to get my damage, which now I can prove to some degree. And also, because it was willful, I want you to triple it.
Yeah.
Because it's also a copyright violation. I'm gonna throw that in somewhere, maybe, if I can.
Yeah.
So that's the way that works.
But so can you only do that though? So like for this one, could you only get
There
the
is an
injunction
app,
for
but I
4
couldn't
years?
tell you that.
So in a case like this,
Yeah.
could you only get the injunction for 4 years? Can you only get the injunction for like the amount of time in which the contract is for?
Oh, yeah.
So like for Kesha, I mean, they can only do it, you have to do so many albums and then once you're done, you're done. But so for here, I mean, he contracted for 4 years, so they can get an injunction not to work somewhere else.
He can sit for 4 years if he wants to. Then he can go out and work.
But do they have to, but would they have
Then
to,
you'll probably get sued for damages or something. You might. But yeah, you can sit and then you can go work. You can do that.
but I don't see how it works.
I know an artist that did that. He just sat out his contract.
I don't know how that works in this case because
Do that if they want.
the judge can't order the firm to hire him, just like the judge can't order the employee to go work for the firm. So
Well, that's not necessarily true. I know this sounds really weird, but they won't, but
they could, well, no, in the case we read, they could.
could.
But I mean, if you're giving the guy an injunction saying, you know, you can't work anywhere for 4 years, he's kind of out of a job and law school is useless because if you can't work for a law firm for 4 years and then the judge can't make these people hire him for the 4 years of the contract, because I'm sure neither of them want to work together anymore, then he's SOL for 4 years and has to go work at McDonald's?
I'm not even sure he can work for McDonald's.
Oh, he just can't work at all.
That might be true.
But that seems like indentured servant, because where's he going to work? If the judge can't order the firm to take him and the judge can't order him to go to the firm, how is he supposed to make a living? I mean, that seems against public policy in and of itself, too.
From the firm phone to
Well, he signed it. I mean, I don't know what to say. He took the money anyway, so he didn't sign anything. But the thing is that's why it's, you know, that's why you don't do this. I mean, that's the short version. But, you know, and it's funny because, again, I think a little more in record terms, and it's like, again, it's about optioning records. So you can't make records for anyone else's. That's how that works. Kesha can go work for McDonald's if she so desires.
Yeah.
I'm not exactly sure what the exact thing that this guy can do is, though, because he's got a, I don't know if he can go outside of the, I don't know. I honestly.
I mean, what is his best option to go there, work, be crap, and get
In
fired?
California, he probably could.
I mean, that's really his only other option.
I think that your first idea is right, that nobody would ever order this. You're already in a court of equity. The idea that somebody's gonna order somebody to
To not work for 4 years?
is like, it's ridiculous.
It was not gonna happen.
It's ridiculous.
Never
I mean-
in California. So that's not gonna happen, but I'm thinking maybe he could prevent him from going to a law firm, but why would you wanna do that? Because he's got these inequity, why would you wanna stop him for that?
You don't.
competition.
No.
It's not fair, and it's not beneficial to the economy. It's not beneficial to anyone. There's no way you're getting that in equity. I mean, to me, it's to the point of like ridiculousness.
Yeah.
You know.
Well, it's against public policy, you just can't do that.
Well, even the non-compete clause, it's like limited to mileage, right? Like more than 5 miles or something. The non-compete clauses.
No,
Oh,
it's a
it's-
reasonable distance.
Reasonable.
I mean,
Reasonable distance for your
probably better.
locale.
Yeah, I mean, there's some things you just look at. And
Distance
if
in
it's more than
years.
5 miles, that's bad. Usually, if it's underneath, you kind of, that's just kind of a guideline. Yeah. 2 years, 5 miles. Yeah, it's probably, if you're over those, you kind of, you're getting, I don't know. Yeah. I mean, really, the only time I know of that it's really funny, the only time I know of that they actually enforced a non-compete that I know of was for nail salons. When there was a new nail salon moved into a mall. And so they tried to draw away all the employees from the one that was already there. And the court said, not in the same mall, no can do. And it had like a 5 mile radius thing. So they said, this is one that's fair. They should expect.
I can see that one.
Yeah, the employees taken away. So That's one I know that that was actually enforced, strangely enough.
So then I guess to go back to Will's question, I mean,
Yeah.
would you just kind of set this up if you're going to do it in the contract approach, which I don't understand the
I
rules.
think you have to,
But
It's the only way to go through the past performance, and the illusory promise to me is big here.
I guess if you can raise illusory on its own
I don't know, man.
and still talk
At that
about
point, you don't have an offer and acceptance. I mean, you like,
That's why I would end up stopping it if I did that. But so would you just do like, okay, so you're gonna go through the contract, you're gonna do offer acceptance consideration, statute of frauds, and then you're gonna go into the defenses to performance, which would be the unconscionability against public policy, and then detrimental reliance and estoppel. And then like do a separate heading that's like equitable remedies, and then go into like latches, or I guess public policy would be under, I don't know. The only real equitable one is latches, and then to talk about like the 13th Amendment for specific performance, because that's
unconscionability.
the equitable.
So that's a good question, actually, because my instinct would be to do statute of limitations, bailiff, bring latches right away. Because to me, they almost are like brothers, right?
fair enough.
But they're not. One's
One's
illegal
one's
and one's an equitable defense. So do you think that a bar grader would expect them to be categorized together, or categorized under, these are my legal defenses, these are my equitable defenses?
I would break them up.
You would break them up into, okay.
And then what are equitable, the only equitable defenses that I know of are latches and unclean hands.
Well, how many do you need in this case?
I think you need a shit ton of defenses because that's all they asked for.
Well, I like unclean hands, and I would throw in unclean hands too, because
I
both of
wouldn't.
them are acting in, they're both acting kind of, oh, I changed my, it's unclean hands for sure. Neither of them are acting in good faith, in my opinion.
But what, I mean, other than the terms of the contract, which I mean is more of an unconscionability thing than an unclean hands thing, isn't it?
But I would bring up both anyway.
So but are those the only two equitable defenses?
Isn't
Well, latches is an equitable defense, so
Well, latches and unclean hands. I mean,
Yeah.
other than those, what are the other equitable defenses?
Equitable defenses?
Yeah, because it says what legal and equitable defenses
I can think
Chris
of one
raised.
more that I would try to pull out of Rabbit's hat because I like it because it's money involved. What would that be?
The only one I can think of possibly is impari delecti, which I don't think
Well,
is,
but that's like,
that means you're the same
What
thing.
did you say?
well, there's money involved and maybe someone wants their cash back, so I might try for that. If I can't get it at law, where can I maybe get it?
Yeah, well,
So you're asking like rescission? Like where?
Close. I want my money back.
well, then it'd be innovation.
No!
I want my money back. Replevin? That's the thing back.
That's the thing back. How can I get $120,000 cash back? I can't get it at law, but I might be able to get it.
An equitable lien?
I want like my restitution.
Yes,
sort of.
restitution. Why not
Okay.
restitution?
But isn't that a legal remedy?
Well, it's money for stuff
It's
back.
technically, it's both, but usually it's considered a equitable remedy.
Restitution is an equitable remedy?
Actually, you use it when there is actually no contract, but some kind of goods, some kind of money was put out in service of a contract that didn't exist. I want it back. How do I get it back? I don't have a contract, so I can't get it back through.
I thought that was
Right.
quantum merit.
That's for
No,
labor.
that's for services, work.
Oh, that's
Restitution is goods / money. Quantum merit is for the work that I put out.
okay.
Different, right?
Yes.
And again, to me,
I never really thought that difference through.
I mean, to me, it's just like, how do I get my money back if I don't have a contract? And restitution is the only thing I can think of in equity. I mean,
But isn't that more estoppel if there's no actual contract? Like I relied to my detriment that I thought there was a
that's
contract.
possible. I could say that's possible, but
So is
how do I
estoppel
get my
an
money?
equitable remedy? Or not, an equitable defense?
Oh, there's both.
Or is that
There's
also both?
equitable, there's estoppel, and there's equitable estoppel. There's actually both.
So would equitable estoppel be more like the restitution? Like I thought there was a contract, so I did this and
Yeah.
reliance of the thought that there was a
Yeah,
contract?
it's more like, yeah, there really wasn't a contract, but we acted like there was. It failed for some technical reason. Remember that case about the painter that we went over?
I think I painted the wrong house.
Well, that one too, but remember that you probably don't
Remember
remember, it
that?
was
I
so
wouldn't
many
have
years
painted
ago.
That'd be fun, there.
Remember the crazy case we learned about property back in the good old days about the guy who really, he claimed he was an art dealer, but he really worked in a delicatessen. Don't you remember that case? Oh,
No.
I'll look it up for you again. That was a case, that's the case that explains the difference between legal and equitable.
The stop.
Okay.
Oh.
That's why the case was in your book. So, yeah. Anyway, so, I mean, the only real difference is one is statutory and one's not. So, to be honest with you, like, the statute is, but the equitable is more broader than the statute. So, anyways,
And then would you raise statute of limitations in this one? Even though it gives you that the statute of limitations is for 5 years and it's only been 3?
well, it's actually kind of a good latches argument because it's like I'm within my rights. You know, so what do you mean that you're being?
Well, it's almost like the point of latches. It's like usually latches are, you're less than the,
You're still within statute of limitations, but you still waited too long. Isn't that like the theory for latches?
Well, or you can flip it around too. You can say, because, latches can't benefit, because really the way that I always understood latches is the other party's latching onto you.
see,
Is
but
it
I don't
really
think that's,
fair that-
I don't think that's like
Yeah.
what that word even is. Like, you know what I mean? Like, I think that it literally, I looked it up just a few minutes ago.
Okay.
That's literally an old French word that means like dilatory, like you were not vigilant. You know what I mean?
Yeah. Oh yeah.
Like, and it's even spelled with a
CHES without the T, right?
LACHESSE, latches,
Latches.
Oh.
and it's French.
Huh?
And so they just dropped the SC and now it's English. And it's latches.
A lot of stuff works out.
That's pretty much how it works, I think. I made that the last part up.
I don't know, not to disclaim
You wouldn't raise latches
That's my historical
if you were
analysis.
past the statute of limitations though, right? Because then you would just raise statute of limitations.
Well, but
Or could
sometimes,
you raise it?
but see, sometimes the only time you can bring a suit when something runs past. See, this has always been my understanding as well. It's like, let's say you blew through the statute of limitations, but there were reasons why.
Like you were negotiating through the statute
or
of
something,
limitations?
right? And nobody remembered to toll something or something. You would say, yeah, but I want the equitable remedy of latches. And you'd say, even though we did blow through this, there's no real reason that in equity I can't bring my suit because nobody has been harmed.
I've never heard of latches being used that way.
It's
I mean,
not fair.
that's what I was thinking,
can't
but-
bring my suit.
Can you raise
I don't use that.
can you raise a defense to a defense? I mean, that's basically what
That's
you're
what's
doing.
interesting though, because it really is a defense.
So you're bringing your complaint, they answer statute of limitations.
Mhm.
How do you answer to their answer with latches and saying,
Yeah.
yes, I've blown through the statute of limitations, but it's because of latches? Is it because they'd have to demur and then they demur on the fact that you've blown the statute of limitations and then you say, maybe so, but still because of latches?
If you blow the statute of limitations, you've blown up your SOL.
Yeah, because I feel like even in like a car accident, if you're negotiating through, and because that's why a lot of people file car accident suits is because they want to preserve the statute.
Right.
I just don't see how latches works as a defense to the defense of statute of limitations.
Well, I mean, I'm just saying there's cases that,
I can understand. I mean, maybe in equity, because in equity, nothing.
Well, and
The rules are
it's
made up and
whatever's
points don't
fair.
matter.
Right. I mean, you're always looking at fairness. I mean, that's why. You're constantly just balancing both sides in equity. There's no rules. It's just do whatever's fair. But for instance, here's another good case.
I like this
Very
description.
interesting case. What about this one where this was an interesting case. Pink Floyd. See, I don't know these great stories about musicians doing these things. I don't know why, but anyways.
The kids?
The kids who sang the "We Don't Need No," they never got paid a penny. And the reason they never got paid a penny is because they didn't think they were owed anything. So many hundreds of years later, not hundreds, but about, what was it, 30 years later, finally some lawyer said, hey, most of these kids are still around. They've never been paid. And the story comes out later, it's pretty funny because all of a sudden, you know, one of the band members gets this genius idea and they just run out to the nearest school and say, hey, y'all got a choir? And off they come. Basic stuff, really. And so here they are singing this part, and then they all go home and they're all happy. And, oh, mommy, today I sung on a record. And then, you know, 30 years later, some lawyer says, did you ever get paid? And they'll go, we're supposed to get paid? Really? Oh. And so they bring a suit. Well, if you're Pink Floyd, what do you say?
Very first statute of limitations.
Statute of limitations, are you kidding me? Okay, the kids fired back, but we didn't know any better. It's forgivable. We didn't know. We were kids. They took advantage of us. Who won, by the way?
Well, I think you told us that they did end up signing some kind of a release.
Yeah, they ended up signing the release.
But
It's something settled. I mean, the kids basically won, but they got paid to go away.
Pretty much. Yeah. But they didn't get paid what they wanted.
Well, no, but I mean, what are you gonna give them really for?
Not
Because
good.
they're only due what they put in, which is really a little bit of, you know, today you can do that just synthetically, you know, or not synthetic, whatever it's called.
Okay.
Yeah, just,
Well, synthetic. It's,
you know what I mean when I say synthetic.
no, that's what I mean exactly.
I'd have to see though if they threw it out. Like, did they throw it out because they found the releases, or did they throw it
Well,
out?
no, they eventually signed the release.
They consented. They consented.
As adults, they signed off on it.
Oh, I thought you said like in the end it came out like the parents did sign some kind of permission slip type thing or something like that.
Ooh.
Oh, the parents?
Yeah, I thought you had said that for like the last time you told us the story. Like it had come out that they did send something home to the parents or something like that.
Yeah, because
But I mean, I want to know why it got thrown out. Like, if it got thrown out because of that, then they obviously never decided on the statute of limitations thing.
Mhm.
But I mean,
So what is, there we go, what is equitable tolling? That's what we're talking about.
Well, equitable tolling is just the idea that,
Yeah, it's kind of like what you're saying as far as
yeah.
plaintiff's latches.
In other words, it was through no fault of our own.
Yeah,
That's
So
a
we
statute.
should equitable toll the statute.
I think that's kind of the, okay, you got it, fair enough.
Okay.
I like that phrase for it. If it comes up, I'm gonna use that phrase.
but can you get damages on in a court of equity? Like monetary damages?
No, you can get restitution.
Yeah. Oh, restitution.
Yeah. See, that's how you get money. I mean, you can get money, but you can't get.
You can't get like
Well, although
consequential and all that
theoretically,
stuff.
I mean, you know, again, the judge could say, well, I think you should pay damages. I mean, they probably would. That might be the reason why you might use quasi-contract. You know, because you might say, okay, but I want to fashion a remedy that looks like expectation damages. That they could do. That's why they do it, by the way, for the most part. It's like, yeah, but the contract remedy works better than any of this stuff. So I'm just going to say, add one, let's do a damages analysis and be done like that.
Yeah.
So that's true.
Yeah.
Interesting. Okay, well, good.
I wonder how to write these things again. It was nice when it was a known quantity, like the baby bar was like, okay, we're going to get 4 exams, there are 3 topics.
Yeah. Those days are.
Well, you're going to get 5 exams, and there are 15 topics.
And they're all,
And they
they're
can be
worthy
merged.
of themselves with a zillion kids.
Exactly.
That came out wrong.
I got where you're
going. And they produced a zillion kids.
Okay, so, let me just, shoot, sorry about that. Let's just go over their answers real quick. I'll just say what they said, both of them. Okay. Good job. All right. A,
Officer, secretary, applicable law, officer.
controlling law, valid contract acceptance. Then notice it's.
I'm very glad that's very baby bar like, because I'm very afraid of writing the bar, because I still write everything in baby bar style.
Oh, you can still do that on the bar. It takes longer though.
Does it?
I think.
I feel like I can do that so much faster than writing a big block and be like, okay, what words do I need to underline and highlight?
Oh, I could run block so much faster. I can't. I can tell you that. Consideration, illusory promise. Promise is illusory even if there appears to be a legal detriment if one party is not bound to do anything at all.
Is that a defense to formation though? I thought that was a defense to.
No, that's formation.
Okay, that's not for lawsuit.
Illusory promise. Promise means there was never a deal to begin with. It fails for lack of consideration.
Wait, which one?
And no, the
Illusory?
illusory promise would be it fails for lack of consideration. That's what that means.
Right, so one
Never
side,
was
I thought it's
one
because
side's promise, he doesn't have to do it.
Yeah, there's no mutuality
of detriment or.
of
I thought illusory meant like
Here, it's based on this weird contingency.
well,
that
I think what you're thinking.
the
is-
one side can decide whether it wants to perform or not. Like it's up to that side whether they're going to
That's
perform
possible.
or not.
Okay.
Yeah, I mean, you can use that more than one.
Like with them, like
Yeah.
you'll become a junior partner if we decide that you're superior.
Right.
It's a illusory promise right there.
Well, yeah, no, it's illusory, but
That is illusory,
Okay, well,
that portion of it.
here, law firm can control Chris's performance reviews
yeah.
and appears to give law firm complete discretion. So we can go there too.
I just didn't see it as a lack of performance. I saw it more as a you control your end of the bargain. There is consideration, but you control whether you're going to pay it or not.
However, they don't feel it's illusory.
Oh, they don't feel it's
Yeah,
illusory?
I should read that. Yeah, they think that in all instances, the law school would have to use reasonable methods which could be evaluated. Okay.
Sure,
Statute of frauds.
yeah.
Good, I like that one. Yeah, I think that's pretty good. Part performance. Not bad.
He went to law school.
It seems like,
Here's one we both missed. Is he a minor?
No.
That's pretty good.
Why would he be a minor? He's already finished 4 years of
I will assume
undergrad.
that he is not a minor.
Well, yeah, because if he's going to law school and already working as a paralegal, then he's probably already finished undergrad and he's at least.
So can we leave out the 14-year-old prodigy from Harvard defense? Okay, good. I like that thinking though. See, this is how I.
Yeah, I wouldn't have
That's-
added. I wouldn't have added that.
I would not
Would've been
have
safe.
I think I would have skipped right over that one. Unconscionability, I think that's huge in this case. I can't even check how huge I think that is. Defense to specific performance, okay, good. Legal remedies are inadequate in terms of definite certain, there are no remedies, good, okay. Problem is what?
There is a legal remedy.
That's one problem. And the second problem, I think, is
13th Amendment.
the 13th Amendment to me would be pretty huge, although this answer doesn't even mention it. Feasibility, oh, that's better. I don't know what that is, but further that violates the 13th Amendment, so they put it under
Feasibility? Oh.
sure, 13th Amendment. Latches, that's what I wanted to read. Let's see what they thought the bar liked. Chris can also assert the defense of latches, good. One can defend on the theory of latches regardless of the statute of limitations, because they are completely different theories.
That's more of
That's
a,
genius.
the statute hasn't passed, so
Yeah.
I can still bring it.
Latches operates when a party has unreasonably delayed assertion of their rights so that there is prejudice to the other party. Okay, so that's the straightforward one. Here, law firms said they would nonetheless support his choice of employment and commended Chris on his integrity and social conscience. Again, that never happened. Chris reasonably took this to mean that he was not bound by the contract to work for a law firm and that the law school expenses would be paid regardless of the decision. He's an optimist. Further, law firm waited 3 years to file a breach of contract action. Now that's interesting, but it's within their right to do. Oh, great question. Chris has worked for the Advocacy Center for 3 years at this time, and for Chris to go back to a law firm of paralegal agents would constitute severe prejudice.
Probably
That's-
make more.
That's, yeah, I hope so. More than paralegal.
Just thought about the,
That's,
makes sense now. Now that he's got experience, he knows how it works, so if they sued him when he was a youngster out of law school, he wouldn't have been able to make money to pay off the lawsuit. Now that he's got 3 years of experience, he could probably generate some money to pay him back, so now it's a good time to bring the lawsuit now that he can actually pay.
well, and you know what I would, I would make him work for me, then I'd fire him. instead.
But then he gets out of the contract.
Yeah. Thus, Chris can successfully assert the defense of latches. Very good. Unclean hands, they threw that in there. Okay, again, it's kind of pretty straightforward. They like it. They think the mean evil law firm took advantage of him. Defenses to recovery of the law school. Chris will argue the law firm made a gift. I don't really like that argument. That's okay with me. Waiver, that one. And promissory estoppel.
Is waiver legal or equitable?
Legal. It's a legal defense to a condition in a contract.
So they didn't separate any, they just went down their list from best to worst.
That's true.
Answer 2, contract formation. Here's the block one. So they did it 2 different ways. So that's fine. Statute of frauds. Nice argument here. I'll give it to you. Unconscionability, again, I think that's huge in this question. Good argument. Arguably of the 2, I like the second one a lot. Personally, the second one would be what mine would look like. First one, interesting, but here's one. Ooh, misrepresentation.
What's the misrepresentation?
That's an interesting. Misrepresentation is the intentional making of false statements of material fact. It can be affirmative or it can be through silence. True.
Okay, sorry.
True. Silent misrepresentation is typically found when one party enjoys a fiduciary or special relationship with the other. Stays mum about pertinent facts that the other party should know about in order to make a knowing and intelligent decision. Person may claim through law firm through lieu misrepresented by keeping silent about the pertinent aspects of the contract when he had the responsibility to apprise C of his rights and obligations.
In California, it exists. It's called concealment, but it is under the rubric of the misrepresentations. It's like fraud is actually in California called intentional misrepresentation, and this is called misrepresentation of concealment. Like if you look up the code, but not the code, the jury instructions, like the legislator looks it out for you.
Okay.
But
well, they're under fiduciary.
There's no, I don't think there's any fiduciary duty here, and I don't think there's any duty for him. Like,
unless he's still the employer.
No, concealment comes up in fiduciary cases where, like, they're your agent and they're going off making money on their side. They're a married couple and somebody's hiding money. They're they're your broker and they're not disclosing material facts about a house. Like, it's concealment, right?
That's concealment.
Like it's
not disclosures.
But I think you need a fiduciary. I think it's stupid. Sorry.
Yeah, I'm just not sure how they're. But how are they? Just because they're a law firm doesn't mean they're a fiduciary.
Is it?
That's weird.
Yeah, no, I don't see the fiduciary. I also don't see the misrepresentation.
Well, I mean, I see them as being.
I mean, you don't have a duty to tell someone you're about to breach your contract. I'm going to sue you.
And no,
you don't have a duty to do that.
You don't have. Well, you certainly don't have to tell them about your legal rights.
No.
Well, there's also no misrep up in the contract.
No, there's no misrepresentation in the misrepresentation they're arguing is in his decision to let him go work for the advocacy center.
Oh.
Because they're saying, no, you go, don't worry about it. You're a good person. And then, okay, we're going to sue you. Because I didn't tell you your rights and obligations under the contract.
The interesting thing is that
That's
this guy spent 5 minutes writing nonsense and still passed the bar.
It was a model answer.
Well,
This is not.
but
It's not an answer.
I thought model answers go into reread.
Well, that's what Alana and Mike told
That's
us,
what
and
they
it's not
said.
true.
Yeah, no, they do say they'll. Well, not all of them do.
Okay.
But they say that sometimes they get caught in rereading. That one person will read it and just fail to paper, think it's nonsense, and someone will reread it and go, "This is genius." Apparently, that does happen sometimes.
Oh,
So they're not the
I thought they were all in reread. The only reason why they got put through is because they've been in reread.
yeah, no, Mike and
And
Alana
so all
told
of
us-
the good ones
I don't know.
aren't model answers.
Yeah, Mike and Alana were like, if they're a model answer, they've gone through reread, they almost failed, and that's the kind of law you're getting, is somebody who almost failed, and you're seeing how an almost failed person set it up.
Yes.
And they only caught it that it was good in reread,
And
it's probably like in 65.
Well, let me just say that if your paper looks like let's just call it the Barbary model, right? Looks like everybody else's, you pass, which is nice, but you won't be
The model answer.
extremely unlikely.
I remember
That's
Harvard or
That I've been
Stanford.
told many times.
regale.
Yeah, but I don't know if that's, and again, I don't know if that's I mean, I think maybe from time to time someone reads something. If you write 85 on paper, it will get a reread. Someone will look at it and go, what did you give it an 85 for?
Oh, okay.
So,
Well, that's not what I understood when they said went to reread. I understood
Yeah, see,
when
I'm
you said that means that they sucked, they failed,
yeah.
and then somebody came along later
And
and,
said,
and since they read it twice, it just became a model answers. Like they don't care about the model answers.
Right.
But that's not true. What you're saying.
Well, it's not a requirement.
It's not your understanding.
I understand that does happen, but that's not a requirement.
Okay.
Can't imagine that's how it is for the bar. I mean, I'm sure they get enough smart people from these top law schools that write magic
And it's
answers.
certainly not for the baby bar. The baby bar is like they look at the top papers, the grades, and they confirm it. That I happen to know. So,
I think we do the same for the bar.
Yeah, I would imagine so. Oh, you got a 90? Okay, you're a model.
yeah, why?
Yeah.
Even if they like it, it's the model answer. Yeah. Specific performance. We'll talk about that. And
Hold it
then,
like a 90?
okay, unclean hands and latches are being made very
Contracts.
Oh, here's one more. Restitution of the 120K. There we go. That's why I like the second better.
But that's not a defense. That's not a defense.
Well, it's a remedy.
Yeah, they want defenses.
Yeah, 'cause I would talk about this too.
But why?
Because that's how the law school would get their money. Law firm would get their money.
Yeah, but we don't care about the law firm. We're asked, what are the legal and equitable defenses that Chris could raise to defeat the relief sought by the law firm? We don't want to give the law firm the money. We want to defeat the evil corporation.
But let me ask you this then. Because I like the way he did this, though. This is pretty smart. He talks about the waiver, though, in terms of restitution. I'll let you read it.
Okay.
It's very real.
So what are they
Well, you
waiving?
waived.
What are they
Why can't you
waiving?
get back to
They're
it?
waiving their right to the 120.
Anyway,
Well, I feel like they're waiving their right to the entire contract.
Okay.
I mean, because they're also waiving his 4-year term.
It's too lax.
But I wouldn't put it under restitution.
Well, again, these are not axles. Okay, we will not learn
These
to
are
write
excellent.
like this. Okay, none of it. We will not be learning to write like this. But I'm just pointing out that to me, it's again that restitution I like because it's just I hear it's $120,000 that might be going somewhere. If I don't tell my client we're asking for restitution and the contract fails, guess what? I'm in an enormous amount of trouble, don't you think?
But that's only if you're representing the law firm, and then here we're representing Chris.
Right, but even if I would say to Chris, this might come up, and I ask for the money back, we gotta discuss this, and he's like, well, what if we don't, da-da-da-da? It's like, we don't have a contract, blah, 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 or whatever, or you waive the contract, so you have it. Maybe they'll go into equity and they'll try for restitution, because you were what? What's the 2 words I always say? The minute you see that, you just go right to equity. Restitution or quantum merit, you almost always have to throw it down because Chris is being what? That's all I need to know.
Something enriched.
Chris being unjustly.
Wrongfully enriched or something.
Unjustly.
Unjustly enriched,
He
that's it.
didn't do anything for the money. Is that so? He didn't do anything for them for the money. Yes or no?
He was
I gotta
great.
ask for restitution.
He was a
Great
great
paralegal.
Real world
Great
stuff,
paralegal.
too. You gotta ask for restitution. It's unjust enrichment on his part. That's crazy.
Well, I get that it's unjust enrichment on his part, but they only ask him for defenses. That's why I wouldn't raise it.
He better
Because,
come up with a defense if he wants to keep the money.
but yeah, I'd say waiver. I mean, I would just raise waiver. I wouldn't.
That's why I looked there. Truman. Thank you.
Yeah, no, I would.
Interesting how he did that. I like that.
I would raise waiver, but I wouldn't do it under the head note restitution
That's weird.
because they're asking for defenses, not remedies. And restitution's a remedy, not a defense.
Yeah.
So I'd be like, waiver. They can ask for restitution of $120,000, but he waived this.
Right.
I mean,
But how
I
does he
get it.
bring it up? I mean, that's
which
the
is
line.
wait. I mean,
You could just say waiver.
it's kind of the same way that I would have started it with statute of frauds, and then within statute of frauds talk about offer, acceptance, consideration, because they only ask for defenses. I mean,
That's true. It is, but that's interesting because it is.
it's just a weird
at that
call.
point, it is sort of strangely written to center around defenses, though.
Yeah, it's just a weird call to question, which is why I wouldn't have written about the underlying contract on its own. I would have made a head note for a defense, because that's specifically what they're asking for.
Now I see what you're saying, okay. Yeah, because it is an odd call.
Yeah.
It is kind of, you have to take.
They're not really saying what remedies and what defenses, they're just saying, what are the defenses? That's why I'd be very scared to talk about the underlying contract, because I don't want to prove it one way or the other. I just want to say, okay, here's the defense to why the contract's not valid.
Yeah, well, yeah, I mean, it is an odd call. It is really strange.
Just like I wouldn't put restitution, because I'd be like, I don't want them to look at it as, okay, they're talking about remedies when the call's asking about defenses. Like, I get that you're defending against that remedy, but I wouldn't put the remedy as a head note, because that's really all they read.
That's a yellow point? Okay. I'm sorry to talk about as I would not. I mean, that's actually my answer, believe it or not, I don't negative. I would talk about it because I wouldn't not. Dear Bar.
I understand what you mean.
Yeah, I mean, but this was a
Would you not?
this was a cheerleader big time. People just completely blew this out of water. And I'm telling you, the average paper that I saw, that was like a 55, it was just weird. I'm not blaming them, but they all started with unconscionability.
Sure,
That was
that's exactly what I was
pointing that out. I saw all these papers that failed, they barely started there. Word to the wise on this one.
Yes.
Go home.
Got to do your cases, now if you do a good job, then so be it. So why don't we, okay, break time, no, after
8?
8 o'clock is good. I'll start up again at 8.
Get out of here with your cancer sticks.
Okay, we'll do our cases, there's not too many tonight. They're not terribly difficult, did anyone have trouble with the cases?
I just didn't like,
I don't like them.
I didn't like the state claim. I don't understand any of the state claim stuff. Like the 11th Amendment, like all that
Not, well,
crap at the end of the section.
well, fortunately, the 11th Amendment I can explain to you. Strangely.
we supposedly received NPAs that were wrong. I kind of know taxes. Probably. That's what Will said, he said $10 today. I forgot. Okay, well, I already did my tax, I already got my return, but I started freaking out because I'm like, I know the tax law changed. I was like, maybe some firms I don't qualify anymore, but like, I don't want to pay tax, the IRS.
Unable somehow, which was on my own. And whoever was at the time.
Yeah, we left for. Okay.
I
just wanna make sure that we got
got. We were here and ended up staying in
Okay, yeah, I was just like, I just don't want to go back. And then we did the
We
IRS.
had an issue last year.
Last year, because they said everything over the 2015 tax year, so the 2017 tax year. So it's like tax over the year. I said everything, but why didn't you use it and what are you even do to fix it? So, wow.
Yeah, it's been from her.
Okay, well.
Maybe that's what happened.
right. Aha. All right. I knew I met her somewhere. Someone sent me a Facebook friend request. I get basically none of them. I'm like, why am I doing this? Now at least I remember why. Because I never met her. I think she said something about it. Okay.
Have you ever gone through your messages and checked other messages, which are from people that aren't your friends but sent you messages? And sometimes it's people you know, but you had no connection.
Oh, yeah, I check that about once every 3 years. I go,
Okay.
oh, why did you send this here? I wonder if nobody sends me. All right. Okay, ready? We all ready?
Okay, everyone.
Verse 16 we start today. Okay, substitutionary or specific relief, part 2. So this is just our continuation of what we started last week, right? Okay, substitutionary tends to be money. Specific relief tends to be religions. So we're looking at the difference between the two, et cetera, et cetera, et cetera. And so we've been talking about a lot of the problems that come out, particularly with these injunctive types of relief. You know, there's burdens on the defendant, there can be burdens on the court. Again, when it comes to the defendant, of course, it's more of a balancing test. When it comes to the court, it's just, you know, it is what it is. I mean, courts can only effectively, I mean, courts are courts. I mean, there's lots of things they should and shouldn't be doing. And they certainly get involved in things that, you know, they can get masters, they can get specialists, all these different types of things. But, you know, it's an interesting issue. You know, how effective can a court be, and how long can they hang on to some of these issues? Which again, sometimes is very long. You know, with considering the fact that California is a wait and see state, and we're willing to wait 90 years, I guess, at least in some instances, there must be some idea that, you know, we can wait and see. Other times it may not be as practical, I suppose. It's certainly expensive, if nothing else, I have no doubt. Just throwing that in, I mean, I'm sure it's not cheap. But with that said, we got a case here, Whitlock versus Highlander Foods, Inc. Kind of interesting, you know, defendants, that's the grocery store, right? Highlander arguing about a property.
That's the wall.
Right? A wall at a
And the
property.
pudding.
The Whitlock? Oh,
Yeah.
okay, sure.
Yeah, so who wants to do that case?
I'll do it. Okay, so in this case, we have a guy who is building a new wall, and in order to use, there are footings to this wall. So the footings are underground, and they buttress the wall on both sides. During this time, the plaintiff comes out and says to a guy named Castro Giovanni, that you're on my land. This guy says that they'll negotiate a payment for the footings. Initially, he's okay with that. He said he wanted to be a good neighbor. Eventually, a month later, he withdraws his permission because he can't really reach they can't resolve the issue. And then after that, they have to withdraw their workers from that guy's side. So they're only working on one side, but they're not moving the wall. These extend eventually once this is done, they extend 18 inches into plaintiff's property at points. And this is below the ground. By February, their settlement has broken down with the defendant only offering $10,000 for all of this, and the plaintiff wanting $30,000 plus $2,000 a year for 20 years. The defendant's motion for summary judgment was granted on the basis of a lack of intent and a laches. The general rule here is that in deciding whether to order a defendant to remove an offending structure, the trial court must balance the hardship to the defendant against the benefit to the plaintiff. If the former is greater and the latter is slight, the court will ordinarily leave the plaintiff to his remedy at law. So in order to get into equity, you have to the balancing of the hardships must be in your favor. At that point, you are pretty much going to get your injunction. That was the rule before, and at this point, they go through the fact that the plaintiff did not protest the encroachment until after they were poured. They're wondering if he was on some inquiry notice about this. They then go through the latches argument, saying that latches basically rest in the trial court's discretion. There are no fixed rules, but you need to examine all the circumstances. So there's no rule really on that. Their holding is that the court erred in granting both the latches and the intent, because there's just a factual dispute as to whether the defendant acted deliberately, and then regarding the latches, whether they are whether the delay in bringing, it said that they erred in holding that as a matter of law, the plaintiff delayed, because there's a genuine issue of facts whether the defendant's right to invoke equitable doctrine of latches. Yeah. And that's it. So basically, they say that both of these are issues of fact which should not have been addressed at the summary judgment stage. Fair enough.
Okay. So, yeah, not bad. So we have a case. Wall, right? Tear it down, find out that in fact these underground sort of, whether there's some kind of anchors, right? They're under the ground and they encroach upon the neighbor's land, right? There, what is it, 18 inches or something, or is it 18 feet below the ground? Which one was it? Anyways, it's kind of an interesting case in that instance, because they come to him and they say, we just discovered that when we were building this wall, that we're actually encroaching on your land. What do you think about that? And he goes, I want to be a good neighbor, so, what did he say? And again,
We'll work with you.
We'll work with you, but is anything right? Everyone catch that? See, I picked kind of a good essay today, didn't I? See how fast these things get crazy. So apparently one side would it be fair to say that one side thinks being a good neighbor would be about 10,000? The other side thinks that he being a good neighbor would be about 70,000. Okay, that's quite a difference in what makes a good neighbor here. So the question really becomes, though, is that there's two parts to this. And remember that you're asking for injunctive relief, which is essentially what? Fairness. Okay, is it okay to go ahead and, for the defendant in this case is already, the plaintiff has already built part of the wall, right? Is that so?
Mm-hmm.
As a matter of fact, they say to the degree that it's 1.5 million
Right.
into it. So to have them
Pretty nice wall.
backwards is pretty crazy. That's a very nice wall. It's not the southern wall, but wouldn't quite pay for the down payment on that. But notice that there's some really interesting things at the bottom of 417, though, I think, in this case. Is really, what are they really asking? They're just balancing the hardships, right? And they're saying, which is fair. And they make some interesting points, I think, which is kind of, good stuff if you're thinking about how equity really works. It's sort of just a big balancing trick is what it is. Here, the balancing of hardship decisively favors defendant.
So at that point, why was it wrong to grant the MSJ? Because he said, well, there's still issues of fact.
Well,
like,
because
issues of fact, but he didn't get into equity.
right, but here's the problem
What
in
did
this
you-
case. Did they know enough of the plaintiff's, the defendant's disagreement, right? Did they know about much of the problem they were having to the degree that they should have been aware, maybe not to keep going? And then didn't they cause their own problem? It sounds like they did, because if you read the case a little further, let's see.
They still worked
The
on it.
evidence suggests the
So-
plaintiff did not protest the encroachment until after the footings were poured.
Right. So how does plaintiff win this case?
However, this proves little in itself, as the evidence suggests equally that plaintiff and perhaps defendant did not know in advance that defendant would encroach on plaintiff's property at all. So again, keep going. In any event, a mistaken belief by defendant that was on the right side of their line would not save it from an injunction if it could have ascertained the truth by using reasonable care. Don't put your head in the sand. That's what that says.
So the court also went on to say that if you encroach on somebody else's land intentionally, then that gets rid of your laches defense.
The record provides a basis to find that defendant knew that it was appropriating plaintiff's property and pressed ahead anyway. You're kind of dead in the water. The court says that to you. Is it really fair then to award them? I mean, that's
So-
that.
Would you have argued easement at that point or something? Or
Well,
is
I
that
would
what they
argue-
should have argued is
Adverse
easement?
I would have
possession.
argued adverse
Adverse-
possession is actually realistic, except what's the problem with adverse possession?
She wasn't
It's
open
underground, it's not
notorious.
It falls
It was
apart
not-
really fast, so maybe easement would have been better, but nobody knew. See, that's the problem.
So you have to know for an easement too, right? Not just using it.
Oh, yeah, there has to be some knowledge. I mean, an easement's, yeah.
But it just has to be open and
Unless you-
notorious. It doesn't have, you don't have to have knowledge though, do you? Doesn't it just have to be open and notorious so that if they came to check on their property, they would know?
Well, yeah, it's in the ground.
It's underground, so there's no way they could have been open.
I
Yeah.
feel like you can tell if somebody dug in your ground.
No, but before that's what they were. They just kind of.
Well, but you understand, it's not, the wall's fine, it's just they're putting these anchors on it and the anchor goes into it. So from just looking at the wall, you wouldn't know. It's under the ground.
Yeah.
That's what makes this case interesting. Otherwise, it'd be like, these things have been here since 1952, shut up. And you'd have a completely and utterly different argument. But in this case, it's like, oh, look at that, it is encroaching, and then in good faith, they told him about it, and then he said, okay, well, let's work something out, and $60,000 being everything that it is.
So
But you're asking in equity, you see what I'm saying? It's
Right.
different.
this is probably a partial summary judgment just to the equity claim, right?
For sure.
So to me, this is not a resident property, this is a grocery store. Like, I have no problem with the MSJ being granted here. Like, I think the court overturning the lower court's judgment is kind of like, why? You know, leave him to his leave him to his leave the plaintiff to their money damages, you know, we'll find out what they are.
Mhm.
I don't know. I think this is kind
Well,
of.
did you read note one?
Where, I think so.
I mean, it makes a lot of sense. It's an MSJ, right?
Oh, with a bunch of questions? It just said like, sorry, yeah.
Yeah, if you read note one,
This
it's
is
like,
this?
an MSJ is a question of fact, right? And what is this court saying? Why did you grant that? We think there's an issue of fact here. Okay, send it down to the lower judge.
Fine with that.
What's he gonna say? I just told you there's no real genuine issue of fact.
Right.
Anyway, so if you read note one, they're actually
Yeah.
going along the lines of what you said in a very similar vein. There's already been a determination. I know all of it. They're not telling him anything he doesn't know. They're just saying, we don't like how you decided it. I mean, is there any new facts to this? No. Anyone read any new? No. They're just saying, we think you misinterpreted their, oral statements and their actions. I mean, if you were the judge, what would you think? How are you to tell me that?
Yeah, I would come back with a very similar, analysis, differently worded.
Mm-hmm. It's the old cookie story, I told you the cookie story, right? The difference between the trial court and the chocolate chip cookie case. The difference between trial courts and appellate courts, and why appellate courts should never make never ever rule on statements of facts. No. I go up, I get caught for stealing cookies, right? And I go up on trial. And the trial looks at me, and I'm sitting up there and I'm sweating and I'm shaking, and I'm looking unbathed and kind of, bad. And it just so happens I'm not a, meth addict, but they say, Mr. Drucker, we understand that you're a cookie addict and you stole those cookies. and I have chocolate all over my face and crumbs, and I'm going, oh, no, I'm not. No, I'm not. No, I'm not. Okay. Got it? Okay. They find me guilty of stealing cookies, right? You find me guilty of stealing cookies. You find me guilty. Well, you might argue on my defense. I'm not sure why, but you might. You would find me guilty on cookies. Okay. I appeal my decision. The transcript goes up to the court. Mr. Drucker, you are a well-known cookie addict and you stole those cookies. No, I'm not. You really want that decision made out of a transcript? Does this sound like someone making decisions out of transcripts? And it just says, we don't think that you looked at the facts correctly? Is that fair analysis of this case? I mean, when I read it, I say, I guess it's good that they balance the equities, and yes, it is in fairness. You want to make sure you're not benefiting someone because they lied. I get it. That's really the case in a nutshell. But isn't the bigger issue, what's the trial court going to do? Send it back down. I mean, they did send it back down, as I recall, right?
Correct. So the MSJ is not an issue of fact, I believe. It should be, there is,
fact.
there is no disputed fact as to the intent or the lashes. So I think they're just saying that, no, this is fine, you just can't do it at the MSJ stage. You gotta find some other stage to do it on.
So you think they should? You're suiting. Okay.
I wouldn't have
That might
something
be
like that
the-
because it seems like a big waste of resources.
Okay, that might be the implied though. I like that actually. It might be saying you should let the trial fact decide this at a later stage.
Maybe that's what they're, I don't know.
But on the other hand, but then again, should the appellate court be doing that? I'm just throwing that out because I have always found this case kind of, again, what we take for this is it's balancing. They're going to balance all the hardships. You don't want people to benefit from, the hardship that they cause themselves, right? I mean, that's the short version of this case. But, you knew you had a disagreement, but you pushed forward anyway. And they're like, but, we figured, again, it's just all a matter of fact, right? So, anyway, in this case. But, I don't know, we'll see what happens. They said there's also a chance that it might go into a general pool of judges as well. One judge may go differently. But I'm just saying, if I was, I'm not a judge, I never was, probably a good thing, but anyway. But I would just be kind of like,
Well, if I were the trial judge, I would think that there's an issue of fact. If I were the appellate judge, I'd be like, I probably wouldn't take the case,
well, yeah, I would have just said, I think the judge was the guy who knew whether the cookies were stolen or not us. But in this case, I think they seem to be pointing that out, but they seem to be kind of going beyond that. But again, I think that their point, though, is they have a suspicion that the grocery store caused them trouble and they shouldn't be rewarded for that. The court of equity, okay, I could buy that, right? Pardons on everybody, right? Yes, no? Indifferent? Guys tired tonight? Okay, yeah, it sounds a little fun. Okay, let's get through this. That's not too hard though, right? I mean, it's pretty straightforward stuff.
What was the definite conclusion? Did they say what happened at the end? No.
They just sent it back down.
They sent it back down.
and then-
Because it got thrown out at the
Yeah.
MSJ stage, so
Yeah,
they just said, no, there's an issue of fact, we have to try it.
it belongs at a later stage, I mean, I think that you might even, so when does motion on the pleadings happen? Like you just for judgment on the pleadings, when?
On the pleadings?
Yeah, that's it earlier than
That's
that.
very early. It's like the pleadings are just so deficient that they can't even be,
Okay.
amended. Or, or you can just say amendment, I suppose. Okay, Lord and Taylor LLC versus White. It's kind of a new case, 2015. Yeah. Who can tell me about this case?
So Lord and Taylor and Bloomington's, which I guess is through White Flint. So they agreed to open a mall. Bloomingdale's was going to be like the anchor store, and that the term of the agreement was for that they were to remain open through at least 2042, and that Lord and Taylor may extend them up until 2057. So the mall opened in 1977. Everything was going fine, but of course, ultimately shuttered because nobody goes to malls anymore. And Lord & Taylor was the only business, so Lord & Taylor as Bloomingdale's was the only place that was still open for business. So the city and White decided to redraw the sector and make up this big community area that's all outdoors, and Lord & Taylor would become a standalone store rather than in a mall. And so the Lord & Taylor sued to enforce the agreement to have a first-class mall available to them as part of the contract. And White basically said it's unfeasible to require them to do that. And so the court, the rule that I got out of it, that an injunction may be denied as infeasible if it would compel the parties to continue a commercial relationship or require the court to closely monitor the caliber of their performance. And they basically said in this case that the court would have to not only order the mall to stay open, it would also have to make sure that it was a first-class mall, that the people going into the mall were solvent and could carry the mall. And they said that's not what the courts are there for. It's not feasible for them to be able to monitor every aspect of this. So they said that here, specific performance of the contract was not going to be ordered.
Wow, so are you telling me that in a case like this, interesting case, kind of cool, in this context, as in others, trial courts retain discretion to deny specific performance or injunctive release, where enforcement would be unreasonably difficult or require long continued supervision by the court. So for instance, an injunction may be denied as infeasible if it would compel the parties to continue a commercial relationship or require the court to closely monitor the caliber of their performance. Is that correct?
Mm-hmm.
That's basically what we take from this case. Is that what happened in this case?
Mm-hmm.
Anyone not understand that? Moving on. Court can do that. Nope, we don't want them. All right, too hard. 5. I think you can also throw in a little dash of this would most likely not be a good commercial relationship. So we're not going to oversee that you're going to lose money. I guess would be the short version.
I can't believe they got 31 million out of that.
It's a good case there. Okay, Willing versus Mazzacone. This is actually a very famous case for those of you that don't know that.
Over $25.
Right?
It's a very famous case.
That wasn't even a block back in 78, was it?
No.
It's like, how bad is inflation?
And by the way, a sandwich board is a thing they used to wear. Okay, so I had a lot of students say, "What's a sandwich?"
What? It's fun, they say that in his ear and then they walk around.
And they ring the bell.
They used to ring the bell.
Yeah. So here we have a Willie. She's an indigent lady who believes that Quentin Mazzacone stole money from her and sold her out to the insurance company, and she's wearing that on a sandwich board, passing out. I think she was passing out something, kind of giving people a these guys stiffed me out of $25. I should have gone to the doctor.
Yeah.
Even being shown evidence from the doctor and from the lawyer saying, no, we did not take this money. You know, she's still out there, arguing. And, these attorneys enjoying her from doing so. But in doing so, the court's granted it saying, well, in this case, it's really, there's overwhelming evidence. She's mentally ill, she's indigent, so we're going to stop her from doing this. And when she appealed it, they said, well, just because she's indigent, doesn't have any money, does not give you the right to stop her free speech from saying what she wants to say, even though she's responsible for whatever she says. So just because she doesn't have any money doesn't mean you can enjoin her from saying what she wants to say. But she would be responsible for any fees she does later, even if she doesn't have any money now. So there is other remedies for this. You can't just stop her First Amendment right. So, yeah.
So you mean even though that she's completely and utterly wrong, by the way, and is basically making up facts that don't exist, but she still wants to say them, they're not gonna stop their right because that would be a prior restraint?
Yes,
Okay,
exactly.
good, let's move on.
Yeah, then you have to sue the indigent crazy lady for
We
damages.
get damages and
Wait,
it's clearly defamation, so
wait
you have
for
to
it,
pay.
wait for it. Murder.
Right.
Let's
Freedom.
move on.
MAGA.
It's freedom.
Freedom. Wait, I got that one for you. Actually, I read where, when he was executed, William Wallace actually did give a speech. But it's actually very long and it's actually a really good speech. On the internet, he talks about Scottish independence and things like that. And apparently you were allowed to do that before you were, drawn and quartered, whatever the heck they did for you. You were allowed to give your last speech.
We should bring that back.
Yeah.
And by that I mean the public education. Just kidding.
It shall be drawn and quartered. Yes, and so actually he gave this very long and impassioned speech, which I thought was very funny because in the movie version of it, he basically raises his hand and says, freedom. That's actually not historically what happened. He might have done that for all I know. It was actually a speech that he actually apparently read off the paper, but that's it. And no, I don't know what he had for his last name. Which somebody asked me the other day. Okay. Okay, here's one. Again, kind of interesting. eBay versus Mercs Exchange LLC. Again, this is sort of during the whole .com.
I'm up on this one.
Right?
I can do this.
Kind of interesting. Justice Thomas.
All right. Yeah.
You think he knows what eBay is really?
Probably not.
Probably not.
Okay, so Merch Exchange held a patent for an electronic sales marketing, and eBay started using this, and the two companies could not reach an agreement, and eBay didn't stop. So they sued eBay for patent infringement. The jury found the patent valid and awarded damages. And the question here is whether or not a permanent injunction should be followed. And so there's a Patent Act issue here. And the court decides to follow what they're calling a traditional rule, but we'll learn from the notes that this is really the first time that they put in PIN that this is one straight up 4-part test. And so it makes clear, so it's very Justice Thomas. It's like, here's the rule. And so that becomes a similar case because of that. And this 4-part test for when you're going to grant injunctive relief has one, it has suffered irreparable injury. So I'm going to say, okay, so the party seeking injunction has suffered irreparable injury. The party seeking injunction does not have an adequate remedy at law. Balancing of the hardships between plaintiff and defendant, balancing the hardships between the plaintiff and the defendant, an equitable remedy is warranted. And 4, a permanent injunction serves the public interest. In this case, they granted the permanent injunction, and eBay was not allowed to use that thing. I'm not really sure what it was.
Okay.
Cool.
I like the note where they later on they did let eBay do it, and then eBay just had to pay $39. That's all that.
There you go.
Yeah, eventually they just bought it. So.
Yeah.
Yeah. Well, I mean, it's an interesting case because, again, remember it's about intellectual property. And intellectual property works, again, slightly different than real world stuff, particularly when it comes to the remedies section. Numerous remedies are available to you that really aren't available in the, let's just call it the physical world, I suppose, or something. Lots of additional things because, you can probably tabulate damages, but how are you going to stop the future harm? lots of things like that come out of the use of patents.
Kind of feels like you just go to the patent office, get all these really cool inventions, just completely rip them off, make enough money to pay off the guys whose idea you're ripping out.
Oh, they do that.
Yeah, okay.
People do that. That there's all sorts of weird people who do bizarre stuff, particularly with they're called patent trolls, where people will go around and they will look for unused patents and then they'll buy them up and then try to sue somebody saying this was an underlying patent of your patent because it came first. There's lots of people that do that. Companies routinely patent stuff that they, theoretically, if you're like a big company and you're going to patent your technology for the next 5, 10, 15, 20 years, whether you expect to use it or not, just so nobody else can use it for the next 5, 10, 15, 20 years.
Well, that's what Legos is doing. Their patent is up for the little block system. Well, they're patenting individual pieces now, every little piece they produce.
Yeah, that's kind of weird. We'll see what happens. And it's kind of strange stuff. I mean, Monsanto patents their seeds now. So therefore, if a seed blows off a farm onto someone's farm that's not using the seeds, and some plant grows, they sue them for patent infringement. I mean, patents are pretty bizarre stuff. I think they're going to have to stop that one.
Yeah, because
coming out roar about that one. But
well, if I buy Monsanto fruit and I take the seed from that fruit and I use that to start a whole, is that where the patents come
well,
from?
the thing with Monsanto is they don't want you to do that. They want you to keep buying the seeds from them over and over and over again. And so, but the problem is that the seeds get out into the wild and they land on other people's property. And if a plant grows, they sue you for using their patent. It's kind of crazy. And, they actually won a couple of suits and then finally someone went, seriously? And so now they're kind of closing down on it.
I mean, like, if I get the seed from the grocery store from the fruit I bought from them or something, then I plant that.
It's so weird. Yeah. It's look it up sometime. It's kind of bizarre. It's Monsanto. Anyways, we won't get into that. You know what job that what company? Most people don't know this that Justice Thomas worked for before he went to the Supreme Court. It was Monsanto.
Probably a good job.
Paid well. You gotta look the other way and shut
Better
your
than
mouth
the
like a
Supreme
pro
Court
for those
justice.
guys, I'm sure. Those guys make the cigarette companies look like Boy Scouts. They're insane.
Man after my own heart.
Okay, how about this? We talked a little bit about this last week, the difference between preliminary and permanent relief, right? We talked about just some of the practicalities last week. Here's some more unpractical stuff from the Supreme Court. Anyways, who's got Winter versus Natural Resources Defense Council? And yes, I make this easy. It's actually a good case. Okay.
So in this case, we've read it before, but basically they're trying to enjoin the Navy from training using their sonar systems because the plaintiff group said that it was going to cause irreparable harm to the fish and wildlife in the ocean. And the Navy said, yeah, but we need to train. And so the court basically said that I believe that the preliminary injunction was proved. I think, I don't know if it says it or not. But so basically the Supreme Court said that everything, they proved all the elements of to be able to get a preliminary injunction. But the Supreme Court said even when a plaintiff is able to prove all aspects of the need for a preliminary injunction, trial courts must balance the competing claims of injury and must consider the effect on each party of the granting or withholding of the requested release. And here they said that the detriment to the Navy and just the entire economic damage to the United States if the Navy was not able to do their training exercises would be enormous. And they said basically also that if you meet the elements for a preliminary injunction and there was very little doubt that they would win at a trial level, that they would also more likely not be able to argue for a permanent injunction. And they said that it said it would be an abuse of discretion to enter a permanent injunction after final decision on the merits along the same lines as the preliminary injunction. they said that a permanent injunction does not follow success on the merits as a matter of course, and that also with a permanent injunction, you still need to balance the equities and considerations of the public interest. So they said here that just because they would win at the trial level doesn't mean that they should be able to win, because the competing harm and benefit is so outrageously different that the Navy should be able to continue.
Okay, fair enough. Okay, so again, they're using the tests that we talked about, and what this comes down to is mostly just balance, right?
Mhm.
I think the key line here, where I think all the people on the side of the Dolphins kind of read and they went, and it's on 451. For the plaintiff, the most serious. While we do not question the seriousness of these interests, we conclude that the balance of equities and consideration of the overall public interest in this case would tip strongly in favor of the Navy. That's like getting the harpoon in your chest if you're on the other side. Because now you know you lost. That's it. You're done. For the plaintiffs, the most serious possible injury would be harm to an unknown number of marine mammals. That's pushing it. That they study and observe, in contrast, forcing the Navy to deploy an inadequately trained anti-submarine force jeopardizes the safety of the fleet. I would argue too that they point out the likelihood of success versus actual success. This case is pretty much over by then. I also call this the "why can't I have frickin' sharks with laser beams" case. That's my personal opinion, and I'm sticking to it. Anyone want to move on?
I would.
I thought not. Let's move on. Moving on. Frickin' laser beam.
But he ends up getting sharks with laser beams.
Yeah.
So
Why can't I have friends with laser beams?
you can.
Okay. Coin Delaney Co. versus Capital Development Board.
Something false in there. I hear it creak a little more every time.
Well, it's filled with books and it's filled with something in the back. Like it's all filled.
It's not the TV mount bracket. It's
Well, I still argue that I think you guys are still out of range, so I don't know what the hell you were worried about.
Yeah, no, that TV is not gonna fall.
I think I'm gonna get crushed by AJ someday.
Nah, you're out of range too.
You think so?
Yeah.
I hope so.
I hope so.
Look how it collapses.
Okay, Coin Delaney.
This one was a little confusing for me, but so we have this Coin Delaney Co. They've worked with the Capital Development Board before. They've installed some kind of like faucet for toilets, I guess.
Yeah.
And they've all failed. And then he went back and did it again, and they failed again. And so this board now wants their new contractors to use anyone except him, pretty much all his competitors, as a condition for the bids they submit. They're like, submit your bids, but do not use Coin Delaney at all, because this product failed. And Coin Delaney didn't like that, so they brought an injunction to stop their bids from happening, saying, well, you can't do that. It's bad faith. And so the court said, all right, bring your argument about, but you got to put down a bond for this. Initially it was $50,000, but somehow I talked him down to $5,000 because he argued a bad faith argument. So yeah, so what happened then is he got his injunction, and then they halted the project for like a while. So the first bid was like a $56,000 difference from the bid they actually got. I think he also halted the project for like a year with his injunction, or delayed it at least. And now the courts are having this argument where it's like, these bonds are meant to keep to give a prevailing defendant, some kind of reward in case this plaintiff loses, to deter plaintiffs from frivolous injunctions, essentially.
Okay.
And they found you can't. The bonds are there for just because it doesn't have money or something. You shouldn't have reduced it to $5,000. You should have kept it higher. This guy's arguing you should have bought it as high as $560,000 a bond, because this is a big company. You could have delayed their project for 3-4 years, causing them substantial losses. So yeah, so should have done that. You shouldn't have voted because he said he didn't have money or something.
Mm-hmm.
Yeah, so the bonds should be fair to the damage you could cause the people with your injunction.
Okay. Anyone want to comment on this? It's a fairly straightforward case.
You're only entitled to damages in the amount of the bond.
Yeah.
And if you don't argue that the bond should be higher, then you waive that.
You waive, yeah. Which they didn't do. They didn't.
They didn't even raise it on appeal.
Okay.
They just want this done.
Really. Wait a second. Did I miss that?
Oh, am I up? What are we on?
International. Yeah, that's good call. Oh, we did that last night.
We're on the racist one?
Yeah, on the white supremacist.
Alright, so,
Oh, this is a good case.
yeah, this is actually a good case. This is a case where you like want the other side to win, but then you're like, oh, procedure's important. Okay, so we got a white, it is.
I do want to point out that, did you notice who the justice was on this one? Just a-
Fortis, I'm not sure who Fortis is.
He's famous because he was the only justice within modern memory that we threatened with impeachment, and he resigned. He was caught taking bribes.
Oh, wow.
I've never even heard it. I didn't.
Yeah, he didn't sit very long. He was a personal friend of LBJ's, and he should have never. But he was
Wow.
a very dubious character.
So
So he actually was forced to resign.
are they all.
As long as you take no bribes to retire.
As long as they don't leave beer.
So here we have a white supremacist group called the National States Rights Party. Notice the date of this case. So this is being heard in 68.
Yeah.
This is smack in the middle. This actually takes place in 1966. There is a rally in Prince Anne, Maryland, and they are spouting things that are like militantly racist against blacks and Jews. And they have some police in reserve, even from a neighboring county, but they're not showing up at the place. They're just being held in reserve in case things happen, which means that they're not controlling the rally, basically. So the next day they're going to have a second rally, and a group of people came in and got a 10-day order. This white supremacist group appealed the order. So now we're back to the 14th Amendment and what was required for a preliminary injunction, and they need to have notice and opportunity to be heard. And the National States Rights Party won because proper procedure wasn't followed, essentially. So you gotta give people notice and opportunity to be heard.
Even for a temporary restraining order, like I said.
Yep.
Nobody wants to listen to me about.
No. Well, we didn't know it then.
You didn't have case law back.
I know. Thank God for the white supremacists.
Hey, Cardozo over here. He just knows what the law should be.
Yeah. Look at the common sense approach. Give notice when you can.
Okay, so in
Yeah,
other
even
words,
for-
we feel for you that you're trying to pull a fast one. There was no reason really for the.
Well, I'm surprised that you really need notice, and it's like this makes sense because it's a free speech issue. It's really a prior restraint as well.
Yeah.
But just say don't go on somebody's property for 10 days. I don't know. But the rule is you need notice and opportunity to be heard, even to get a preliminary injunction. And
Well, I mean,
There it
okay, 468, first full paragraph. That's the case, really. We need not decide the thorny problem of whether on the facts of this case an injunction against the announced rally could be justified. The 10-day order here must be set aside because of a basic infirmity, right? The procedure by which it was obtained, it was issued ex parte without notice to petitioners and without any effort. That is kind of a problem. However informal, to invite or permit their participation in the proceedings, it got tried. There is a place in our jurisprudence for ex parte issuance without notice, interesting, of temporary restraining orders of short duration, but there is no place within the area of basic freedoms guaranteed by the first restraint argument. For for such orders where no showing is made that it is impossible to serve or to notify the opposing party and to give them an opportunity to participate. So, okay, we're not saying we feel your pain, but don't try to go fast enough. Okay. You have time to do what you need to do. Is that true?
Yeah.
Sampson versus Murray. You want to do that one?
This is an employment case. She was a federal probationary employee. Ultimately, she was fired. And when she was fired supposedly because of reports about her previous employer, which if that was the case, she should have been able to have a hearing regarding it, which she was not given. She sought a temporary restraining order, which was granted, or actually they call it a preliminary injunction. But and the district judge instead granted a temporary restraining order forbidding her discharge for 10 days. Although he stated that he wanted to hear testimony from the official who fired her, the government said, we're not gonna, give him up. And so the judge said, well, then the TRO is gonna stay in effect until you give him to me to question. The government never did. And so they appealed from that TRO order, basically stating that because the TRO had no end, they could appeal it because they could. And so the court here said that when a TRO is granted without a cutoff time, the temporary restraining order actually just becomes a preliminary injunction according to the federal courts. And they said, although a temporary restraining order is not appealable, a preliminary injunction is. And they said here, there'd be no irreparable injury. Basically, this is an employment case. She can sue them for what she would have gotten. She can get money off of it. And that loss of reputation is not irreparable enough for a preliminary injunction. Therefore, you're SOL and you don't get your preliminary injunction or temporary restraining order, whatever you want to call it.
Right. So a temporary restraining order is really a temporary restraining order. And if you let it go too long,
So it goes past 14 days, then it becomes a preliminary.
preliminary, at that point it's appealable. There's nothing really harm here, so adios.
Yeah.
Sound good? Anyone want to further banter that case about? Although it's a very famous case.
Unless you're the dissent, and then
Yeah, but
I don't get how injury to your reputation is not irreparable harm. I mean, how do you fix that? You don't.
Well, I mean, that's the difference in between per se and issues of fact in defamation law, right? Per se is just assume there's damages. In all other cases, you have to actually prove actual damage.
Yeah.
So I don't think it's necessarily, I think the proof is where they're really going. I think that's a fair statement.
Okay.
So, because I agree with you, once the damage is done, you don't.
Well, that's what the dissent says. I mean,
Yeah.
it's your livelihood basically. If you get fired because of something,
Right.
you can't fight it really. I mean, it's your mark for your life.
But,
I guess you can be like, well, I sued them and won, but
yeah, or you can get damaged. Bring your defamation. I mean, the way I read that was always, I mean, it's not a bad dissent, but then I was always like, well, that's why you're doing defamation. The damage is done, it happens. You don't. Although, again, it's not a horrible argument, but.
so how do you argue that in an employment application? Yeah, I was fired, but I sued him for defamation and won. So I mean, I don't know what you want.
And in the meantime, how long are you going to keep this injunction going to
Yeah.
protect the reputation? It's considering the damage is probably already done. Is there really any?
Just bring
I don't know. It's hard to say.
My God.
It's funny. I just don't see that. I think you have that right to go to defamation. Just me, but anyways, unless you're Stormy Daniels and losing that one, but then again, you have to have a reputation to destroy, so probably would help. Okay, did I really say that? I guess I did. Edelman versus Jordan. Okay, what about this officers in official capacity? Kind of an interesting case, actually. Officers in official capacity doing things you're supposed to be doing, they just.
Yeah, this is the one Owen Smith was talking about that was a little confusing. So we have here these is it welfare people? They're the AABD, the aged, blind, or disabled. It's aid to the aged blind. Age to the aged blind, or disabled. That's extra aid. Okay, so there's a federal statute that says, they're supposed to start getting the first payment within 45 days of the application. This Illinois year, they send out the checks within 45 days, but of the date that they determine that they're eligible for the AABD.
Okay.
And so they're always 4 months late on that. And now we have these group of people. Because Jordan, she's suing Weaver, which is one of the directors of the Illinois Department of Public Aid, saying, I want back pay for all the stuff you haven't paid me from 45 days after I applied. And this whole issue of, sovereign immunity arises under the 11th Amendment, saying, well, just because it's a federal program doesn't mean you can sue your own state in federal court.
You can't. That's the 11th Amendment. You can't do that. That's what it's there for.
Yeah, so we're trying to find a loophole around it, saying it's a federal program, it's a federal statute, but they're at the end they found out, you really can't. The new director that swapped out, that took over, he argued that, saying, just because there's this federal statute telling us what to do does not waive our sovereign immunity to be sued. And, Jordan he lost.
Right. I mean, again, it's the 11th Amendment. It was started because what was happening was private citizens were suing states that owed them money who didn't want to pay the money back in federal court. So it actually has kind of a dubious, when did you pay your debts back?
Yeah.
They didn't. They wanted to move on because they didn't have any money. And so, but what happened was they put in the 11th Amendment. They said, okay, persons from different states actually can't sue another state in federal court. Now, it just so happens that over the time, just through case law and things of that name, practicality, a person from the same state can't sue the state either. Okay.
In state or federal court, right?
No, well, the state, you can sue the state if they consent. But
Yeah, they consent, but otherwise you can't sue them anywhere.
That's correct.
Which is
The state is not a suable entity except by another state.
I guess that extends to its officers under their official capacities.
Yeah, and so the question becomes, right, what do you, suits against officers in their official capacities. The question becomes, though, there are some loopholes. Now, for instance, you can sue a municipality. Okay, I can't sue California, but I can sue India, right? Also, I can't sue California, but can I sue the Secretary of State? And the answer is yes, I can. Okay, I can sue also certain officials. However, in this case, which is kind of an odd case, too. I mean, I hope you guys kind of appreciate kind of you're getting paid a little late, and now you want, you're sort of taking federal funds, so you agree to do what the federal government said you would do, but they're sending the checks out at their own time, which essentially denies money for a period of time, and now they're suing for the back monies. But the thing is what did they do wrong?
They didn't send it 45 days after the application.
Well, no, I mean, they definitely.
Was the court too long, or
Yeah, well, why is it that the people aren't getting their back pay?
Because it's not a prospective relief, it's giving them, it's remedial, or not remedial, but let's call it.
Okay, you're so close. Oh my god. Remember when we talked about
it's-
injunctions?
The federal court's remedial power consistent with the 11th Amendment is necessarily limited to prospective injunctive relief.
Yes.
And you may not include a retroactive award which requires the payment of funds from the state treasury.
Okay, let me do my best. Roger Nixon. Anyway, excellent. So can you sue for monetary damages?
No.
You can't even do that.
You can't have an injunction for something that already happened.
Right. Now, it just so happens that it's maybe possible now because of, remember that Bivens case? Or was it, yeah. No. I can't think of it off the top of my head. But there actually was a case that they let go forward against against the state for its police officers, even though it was for back harm because it was so egregious that they actually let them go forward. So there are those instances when now we're thinking constitutionally, you may be able to sue for damages. Okay, in these types of instances, it's possible, but it's super rare. And basically the bottom line is it's for just prevent these things happening in the future. That's why you get an injunction. It's about, getting relief to stop the damage in the future. This is about what? This is about back pay. This is monetary and it already exists in the past. Is that correct? So that's an improper application of an injunction for this case.
I just think it's dumb because you can get the injunction and then you can get monetary damages after they don't comply with the injunction, but you can't get monetary damages before an injunction is issued. Like, you're still taking money from the treasury of the state regardless of what you're taking it. I mean, it's because I don't get it, because what's the difference between going after them for not following the injunction and going after them to make them follow the damn law?
But that's not what an injunction is for.
No, the injunction is to tell them to follow the law, which is dumb in and of itself. But you can go after them for not complying with the injunction. You're still taking money from the state treasury if you're doing that. So why is it okay in that sense, but not before the injunction?
You mean, are you telling me, wait.
Because it says
about that you just said does not work. Where do you
it says once issued, an injunction may be enforced and imprisonment of high state officials is not the only means. Hutto upheld an award for attorney's fees against Arkansas's prison officials as a sanction for bad faith litigation. The court has also unanimously held that the 11th Amendment does not bar the enforcement of consent decrees in which state officials agree to do more than the federal law requires. So, I mean, it says you can sue to whatchamacallit, you can sue after they basically violate the injunction, but you can't sue for the wrong that they're doing before the injunction is permitted.
Yes.
What's the difference? You're still taking money from the state against their consent.
Well, I mean, really, the way that I read it is, what page are you reading from?
489, the very
I
last
read from 486.
full sentence.
That's interesting. Go back to 486, please.
Okay.
Middle of the book, maybe this will help. The one beginning, okay, the Court of Appeals, in upholding the award in this case, held that it was permissible because it was in the form of equitable restitution. So we're in equity, and now they come up with the idea of restitution, which is about what? Money.
Yeah.
So see how they're avoiding the injunction issue, because injunctions are not for getting past money. See, that's what I think they're trying to tell you. So you see how they kind of did a little dance there? This equitable restitution instead of damages. Okay, again, that's how
But
you.
then the next paragraph says that the Supreme Court doesn't believe that.
Yeah, but then they say, well, it is kind of factually different. And I think what they're trying to say is that, but it's just like what you just said. Let me just read this out loud. Let's see, because you were talking about taking money from the Treasury. We do not read Young or subsequent holdings of this court, okay, to indicate that any form of relief may be awarded against a state officer, no matter how closely it may, in practice, resemble a money judgment payable out of the state treasury, so long as the relief may be labeled equitable in nature. Young viewed no such line. So they're saying that the idea that it's equitable in and of itself, that doesn't bar the reward of money. And again, like I was saying, now we've got some case law out there that they're doing it, right? We've finally started doing it. So the 11th Amendment doesn't bar that. It was thought for a long time that it was injunctive relief only. Okay, does that clear it up a little more? So now we're kind of, we're moving away from that. And we've even moved farther in this case now. That's what's kind of interesting. This is kind of old. And now they are starting to say that, well, why is that division there? Now, the old reason was that one is prospective in nature and one is remedial in nature, and injunctions aren't really for remedial. They're stop the harm going further. But again, the court is more and more and more saying that's not true. So that's what I think they're trying to say in this case, is that you don't need this idea of equitable restitution. You just don't need it. It can both be done, right? I don't know, that's the part of it that I thought was kind of a weird. Does that kind of answer what you just said?
I guess. I just. Well, because like a lot of the notes, the notes confuse me more than the cases do, because they go back and forth saying, this case said this, but then this case got rid of that case, and then this case re-implemented that case, and then this case got rid of that case. Mm-hmm. But like it says that like you could do like complying with injunctions costs money, and then reparative injunctions cost money. So you're still able to get money from the state, but you're not like, is it just as long as it doesn't go to a specific person and they're just taking the money from the state to better the institution, then it's okay? Or?
Well, okay. Let me try this. Okay, 487. Now, remember, it used to be that the 11th Amendment barred these awards.
Yeah.
Okay, they were barred. Period. End of story. Okay, because the states had sovereignty. Got it?
Mm-hmm.
So, middle of the Court of Appeals, that paragraph.
Mm-hmm.
Okay, the second, in the middle of the paragraph starts, in deciding whether a state has waived its constitutional protection on the 11th Amendment, which they can waive, by the way.
Yeah.
We will find waiver only where stated by the most express language or by such overwhelming implications from the text as will leave no room for any other reasonable construction. The mere fact that a state participates in a program through which federal government provides assistance for the operation by the state of a system of public aid is not sufficient. So again, I think what they're trying to say is, all that stuff, it's true, but here you have a situation where the states do have sovereignty, they have protection, got it? They can waive, they haven't waived here. It used to be that we would only look, because it was injunction only, it was only prospective. But even since then, the law's broken down more. We're not saying that that's the bright line anymore. See, it's a very famous case. It's saying there's no more bright lines like that. We're going to look at it piece by piece by piece. If in fact we find any of these factors, so you see how they're way widening the 11th Amendment is what they're doing through these cases. And it's gotten even wider now. And I think that's what this case is really all about.
Yeah.
But they don't like the Court of Appeals. But notice how the Court of Appeals did everything that do handstands to get around this. And they're saying, no, just go through the 11th, do it like this, don't go to equitable refuge, don't go to this, don't go to that. And I think that's what they're saying. Essentially, I think they're saying that the lower courts misunderstood what they were saying about the 11th Amendment, even though they understood what they did. So, in other words, we're changing our minds, so it's your fault.
Yeah.
Something like that. But just so you know, it's a very famous case. I mean, that's why it's very famous, because it's sort of widened what the 11th Amendment could and couldn't ban. And so it's interesting, because, it's an interesting dual sovereignty issue, about federal courts and people suing and for what and who. It's pretty, I don't know. Again, it's 11th Amendment stuff. It doesn't get most people really past coffee in the morning, but I really like it, so. Anyway. Okay. Where are we?
I think that's last.
Okay, good. I was going to saying, unless there's something.
Oh, no, there is one more, but Harlow versus Fitzgerald.
Okay, if you're actually doing things in your official capacity,
You're protected.
you're protected. That's what the case says. Again, kind of a famous case. But as long as you're doing, your job, you're not gonna be personally sued if something goes wrong.
Unless you do or shouldn't know.
That is that you're doing it wrong.
Yeah. That's qualified immunity, right?
Well, yeah. But that's the bottom line.
That's it.
If you're following orders.
I mean, if you really
Following
wanna,
orders.
if you really wanna email me about.
The SS officer told me to.
It's actually an interesting case. Again, an employment case, kind of curious. But yeah, that's basically the law.
I just think the 11th Amendment.
Well, it has a very, very, very dubious beginning, like I said, so it is kind of interesting. But on the other hand, we really can't have citizens suing states in federal courts.
Because we run out of money and we can't build roads.
Well, but they're sovereigns. Okay, don't forget they're sovereigns. And one sovereign really, how does it work that one sovereign can sue another on behalf of the same citizen when we admit dual sovereignty? Interesting constitutional question. Yeah. Of course, in my best constitutional analysis, I don't know. It's an interesting question.
I looked at recorded the entire class.
No, this is off, but that was on.
Yeah, well, Sai came in and turned the TV on, but
That's on.
I don't think he ever turned on Zoom to record it.
Well, as a sovereign citizen, I have to say that.
Sorry, citizen.
The people. I like it. Okay, guys, good class. Good class.
Next week or Saturday, right?
Okay, yeah, I will not be here on Tuesday, so I'm gonna have to work something out. I was gonna talk to the powers that be tonight, but I'll figure it out, because I know this
Be
is.
our review.
Well, we'll do the review, but I can't be here next, I know this
Okay.
is gonna sound really bizarre, but they're releasing a movie that I actually was in.
Oh, cool.
And played a part in 1982.
Oh.
And they're showing it at the ArcLight, and they want me to be one of the guests.
Okay.
Good for you.
I mean, we
Oh,
can do
doing-
Saturday. I mean,
What?
we don't do anything on Saturday.
Yeah, we could do it this Saturday, or we could do it
Yeah,
one
maybe.
day, or.
You
That's
choose
what
not
we
to
do.
do anything on Saturday.
I type everything on Saturday.
I think I have a recorded version. to
Yeah, I'll
say
think,
otherwise.
almost for sure we'll do it on Saturday. Okay, so-
Look at everything I submit on ExamSoft, and you'll see that I type Saturday.
I don't know.
Except for one Saturday I did.
Okay.
But